Alok will kindly have Lordship's order dated 7th of March. This matter. 7th of March, Lordship has passed an order. Third paragraph, Lordship had said other respondents may also file their response. The issue is, Lordship, respondents 1 and 2 and private respondents 7 to 11 in this matter have not filed their return. And pleadings have not been closed. So, my lords may reflect that pleadings have been completed if they don't intend to file a reply, because sufficient time has been granted to all of us. And the matter may be listed for final disposal, my lords, the tender matter. We have filed all our pleadings, my lords. The petitioner, we have filed the affidavit in reply to both the affidavit and oppositions filed by respondent 5 and 6.
Yes.
That is reflected in the office note as well, my lord. Office note of 3rd of May 2025, Lordship will see. Our pleadings are complete.
For grant of IMFL off license.
Yes, madam.
So what happened? It's of which 2024.
Yes, madam.
Hmm?
Because what has happened is
This is the NIT of 2024.
July 2024.
So still
Because what has happened is in this case, initially,
it has not been finalized.
no, it has not been finalized. There is an
There's
interim order which was passed.
interim
by
order is there.
Lords, yes,
Interim
of this,
order
or
is there.
this honorable court. The first order, which was passed by
Financial bid of
your lordship, the
the
8th of
financial
October
bid of the
2020.
prisoners be open along with the bids of other bidder on schedule thereto. Your financial bid has been open.
I'm sorry.
Financial.
Whether your financial bid has been open?
Yes, now it is open. Lordship can see the council for the excise department, they have given this, yeah, Lordship, it is open and my client is the Vijay Krishna Gogoi, Lordship. And the earnest money is 5 lakhs. And they have given it is 5,55,000. And my client is given 12,52,000.
Your L1, in that case, H1 means what?
It's I'm the highest bidder.
Highest,
Highest
you
bidder.
are the highest. You'll be given what's there.
So I'm the highest bidder, so there's no Lordship. But then now they want
Is
to.
there any other consideration? Even if you are highest, is there any other consideration?
They said that now Lordship, initially they have opened my technical bid.
That was
and
rejected.
done.
Rejected.
No,
Your
technical
technical.
is accepted Lordship.
Ah. Then
Initially. Then they have come to the court. I'm not a party. They have taken an order. They have gone back there. They have filed a representation. There is no notice to me, nothing. And now this time my technical bid is rejected
on
without giving notice. Lord.
pursuant to the order of this court for
Yes.
disposal of the
Yes.
representation of the.
This court has said you go and file a representation
Yes.
there. But
So
the
your
court is,
technical bid was rejected.
yes, subsequently Lordship.
After,
Lordship,
after,
this
after
court-
opening,
After opening Lordship,
you were found to be eligible.
I am found to be.
Technically,
Yes. Yes.
found to be eligible.
Yes.
Now what remains?
So what?
No,
They-
if technical bid is over now,
Technical bid is over.
you are
financial
against.
bid-
Yeah, no, I'm appealing for 7 to 11 respond number. We seek
What
some
is 7
time-
to 11?
We are private parties, sir.
Huh.
Some allegation has been made in the red petition. We would like to.
No, no. Now the issue is pursuant to the order of this court.
Yes.
When this petition was moved,
Yes.
there is a direction. Order has been passed to open his bid.
Yes.
So it was the financial bid.
Yes.
It has been open. Now it is in the open to public now.
Yes.
It is the highest bidder. Just because you are eligible, there is no other consideration for granting tender to the petitioner if he is the highest bidder.
Lordship will not believe.
Lordship, I
On
am
the
not.
background, my technical bid is rejected now that I have not signed all the pages. Lordship, it is online. It's a tender online process, Lordship. It is going from my email. So
Let us see the order.
all digital signature is there.
May I say, Lordship, Lordship may give 1 week's time, we'll file affidavit in the meantime, Lordship. may-
No, reference was not heard. That means this was Yes,
Lordship, in it 1 week time, Lordship will file affidavit.
what affidavit?
Because some allegations has been made against
See,
us.
It will be, this is a tender matter.
Yes.
We just cannot, just because you are also interested party.
I am one of my respondent,
just cannot keep
whom I am
lingering
appearing, he is not even a bidder in that.
Huh?
Respondent number 7
Huh.
is not even a bidder.
Forget about it. We'll not go into it.
No, the allegation has been made.
Issue is, his bid, technical bid was open,
Yes, yes.
was found to be
Eligible.
eligible.
Eligible. Thereafter.
On you, on the insistence of, on the representation pursuant to the order of this court
Yes.
in a writ petition, the petition, the technical bid of the petitioner was rejected.
Yes.
Without hearing him, even in the court proceedings, right?
Yes.
No notice was given.
That
And while this
department-
petition, and when no notice was issued in this petition, court has prima facie found that without hearing,
Anyway, Lordship, 1 week
his
time.
case has been rejected. Now, in view of that, interim order was passed
Yes.
to open the financial bid.
Yeah.
All right. In the financial bid, he is found to be highest bidder.
That Lordship. Yes, but I'll take only 1 week time, Lordship,
It's a
we'll file
government
affidavit.
revenue, losing
We'll
government.
file affidavit, Lordship. We would like to file affidavit because allegation has been made against us in forming a cartel and also so many allegations have been made.
It's all right. You are
We would
not
like to
getting,
rebut it, Lordship.
now you are not getting the tender.
That Lordship will decide, subject to your Lordship. But
Not where the authority has decided. He is the highest bidder now.
Though this, the petition is the highest bidder, the LOA has still not been given to any of the
We'll,
parties.
we'll close it
Now the,
in view of
now the,
this.
now the issue is that, your lordship, even if assuming the petitioner has been an LOA is given to him, this, the other party who was earlier selected, they'll raise the objection in that. So if I propose the lordship, let the financial bid, let
no.
the LOA not be decided, both
No,
of them
no, why
approach
the-
the DC, your lordship.
See,
Because they said that we were not given
what's
any
the
notice.
question of objection?
Yes.
See, financial bid has been opened.
Open,
The petitioner is found to be highest
highest
bidder.
bidder.
So,
To-
who else to be given?
But they are saying that.
Who
but-
else to be given, highest or lowest?
The highest certificate, but
Then-
since tomorrow this interested party, they again come and raise an objection only, again file writ petition. So I propose a lordship at this stage.
No, no,
They are
that-
saying that we were not given
We
notice, the
cannot-
same
we-
committee who accepted
Sir,
us on
we
the
can-
final first
we-
time.
Sir, we cannot preempt the person to file a writ
Lordship,
petition.
may for a moment. come to
Anyone
this-
can file a writ petition. This can be also be challenged. But
Let
so
him
far
also-
as the issue
Lordship,
is
for a
concerned-
moment, come to page 73.
Lordship may take
Lordship
up
can
after a
resolve
week,
the matter.
Lordship.
Lordship,
I'm
please come to page
praying for a week,
73
Lordship.
of my writ petition, page 73. Page 73 of my writ petition, Lord.
Yes.
Now they say the issue will decide and all that.
Hmm.
Page 73, clause 29, court jurisdiction. The last line.
Any dispute arise.
From time to time shall be subject to the exclusive jurisdiction of the Guwahati High Court alone. It is the Guwahati High Court, if there is any dispute. Deputy Commissioner is nobody, Lordship, as per the tender document. It is the Guwahati High Court will decide. Now they said that this both party will go to the Deputy Commissioner and Deputy Commissioner will decide.
No, sir, this is court jurisdiction.
Yes.
Any dispute.
Any dispute.
It's okay, but then any assembly, then in terms of terms.
Their Lordship may please come to page 67. It is again clear, Lordship, page 67.
Want to say that if any disputes arise out of the bids,
Yes.
it will be referred to the High Court.
Yes, it is no, not referred to the High Court. It is the High Court alone will decide. alone, Lordship, the last word, Lordship,
Now, on what basis? What basis this will be decided? On reference or what?
no, not reference, Lordship.
Hmm.
If any dispute arising out of this tender, Lordship,
Hmm.
High Court will decide. That is the tender bit, tender.
Without, even if, suppose assuming that without there being any petition.
Yeah.
Without any petition by.
No. For any dispute, it is to be filed before the High Court.
Yes, 67. What do you say?
Page 67, clause 15(1). No bidder shall contact the district collector or the tender bid committee on any matter relating to the bid from the time bid of the opening to time of the issue of letter of acceptance. So Lordship is saying letter of acceptance now. So this clause, the deputy commissioner, deputy collector.
Wait, let us see your rejection or the technical bit.
May I apply,
Rejection
Lordship?
of technical bit.
Lordship at page 410.
Lordship will take up at 2. May I apply, Lordship will take up at 2.
Why?
Because my senior is on legs in another court, Lordship.
Page 410, Lordship,
410.
Annexure E.
410.
410, an affidavit filed by the respondent number 5.
Okay, you have not annexed it.
Page 410.
We were not given a copy.
You have not annexed. Rejection.
No. This, we do not know, Lordship. No notice was given to me. I will annex it to the petition, Lordship. Now they have given in their affidavit, Lordship.
40?
410.
410.
The 3 and 4. All pages of the document not signed. Signature of the bidder not found in all document, yes. And annexure is not submitted in the letterhead format, yes. It is a online process, Lordship. It has gone online here, Lordship, through the government. Yes. And it was initially when they have opened, they have said that they all are correct. All other things are everything are correct, Lordship. I have given everything document, all document, Lordship. Now these they have said. And this is a wrong proposition of law. That I will satisfy Lordship if necessary. But at this point, Lordship can see they have given 5 lakhs. I have given 12 lakhs. And Lordship in a government tender, Lordship is a revenue matter, Lordship.
No, see, basically they want to.
Lordship, if
They want to cut you. From
now
the-
my learned friend is saying they want to.
They want to cut you from the root. They want to remove you from
Yes,
foundation.
Lordship. Yes.
Suppose if your technical bid is found to be not.
But they said my technical bit is correct, Lordship.
If
Now,
if it's not correct, there's no. I mean, it's of no use whether you are.
and there is no
highest
power
in
of
the
review,
financial
nothing.
bid or not. Yes. What is to be done?
They won't get time, Lordship, to file an
Lordship.
affidavit, Lordship.
Lordship, again, one
He's
is
saying,
time.
Lordship, he has some
Anyway, it's
problem, Lordship.
I thought I'll dispose of the matter.
Lordship, then Lordship will take up at 2.
Not to. Not Mr. S. Sir, learned senior counsel assisted by learned counsel for the petitioner. Although this court has granted time to file affidavit to the respondents, however, except the state respondents
And this
No, and respondent number
and
5.
respondent number 5. The other respondents have not filed the
No,
affidavit.
my lord, I have filed. I am for the 6 as well. It was settled in my favor.
Respondent number 6.
I am for 6, I have filed my affidavit.
Respondent number 6, 5.
Respondent number 3.
I have filed my affidavit.
Except,
Government.
no.
7
Except
to
this
11.
fine.
7 to 11.
Please stop. The state respondents and the respondents number
6 as 5.
6 have filed their affidavit. Please stop. However, respondents number
7 to 11, Lord.
11 have not filed their response. Today, Mr.
M. Gogol.
M. Gogoi, Land Council for respondent 7 to 11. 6 further, 2 weeks time to file.
1
weeks.
week, 1 week. Lordship.
A week's time to file affidavit. Prayer not being objected to by Land Council, Land Senior Council for Deputy General. Let this matter be listed after.
Lordship may give a fixed date. After 1 week.
My request is that let there be a
Listed after
fixed date.
a week's time, after a week. So as to enable the respondents number 7 to 11 to file their response on or before the
When the
next date.
matter listed, they took time, and then after taking time, they have some urgency lordship. Always.
Just after a
Very
week.
unfortunate.
Just after a week.
Fix a date.
My lord, can we give
It's a IMFL.
I am ready, lordship, do even today. Lordship want to dispose of the matter today.
Nowadays,
After taking
nowadays-
time, they have some
nowadays-
urgency,
I am not
lordship.
taking time, my lord.
Because of the IMFL, everyone is facing a health issue. Therefore, there's no urgency.
There are other reports as well.
I'm grateful. lordship.
After a week. This will be listed after a week.
Yes.
My lord, because
Then
we
the
can-
agreed
just a date, my lord, only to that.
It's after a week, it will be
And the
listed.
date.
Just give whatever.
All right.
You are not bothered about your health.
My lord,
Sometime lordship, I don't know. The last time also he has objected that there is a stay order, vehemently objected.
We're
Matter to
listing
be
it after
taken
a
up, and
week.
Now again today they are taking
my lord,
time.
the issue is that, my lord, suddenly it gets listed because.
It's okay. After a week. All right. Yes, sir.
Wait, with your lordship, my lord.
Yes.
It is a matter, my lord, regarding my lord, establishment of brick lane, my lord.
Huh?
And I've establishment of brick lane, my lord. I have challenged this, my lord, establishment of brick lane on two ground, my lord. It is, my lord, within the my eco-sensitive zone first. And second is, my lord, it is the, it is within the, my lord, agricultural land. And matter was, my lord, heard by your lordship on 6/2/2025. And your lordship made an query in paragraph 9 of the death order, my lord, whether it is fall in the eco-sensitive zone. And forest was asked to my lord to ascertain whether it is eco-sensitive zone. And forest has filed a affidavit. They have stated, my lord, it is, my lord, within the, my lord, eco-sensitive zone. Because my lord, here is my lordship, ever, my lord, that he and Godawaran case. And that case, my lord, that the appeals court stated, my lord, if the demarcation of the eco-sensitive zone is not finalized, in that case, my lord, 20 kilometer will be 10 kilometer will be considered as a eco-sensitive zone. In this case, my lord, Pavitra Reserve Forest, my lord, that was, my lord, not till now, it is not been declared, boundaries not been demarcated. In that case, my lord, it is 10 kilometer. But from the, my lord, they have stated, my lord, it is, my lord, from the, my lord, Pavitra Wildlife Sanctuary, it is brick lane, my lord, is situated in 1,000 or 200 to the 1200 meters from the reserve forest. So it is within that, my lord, eco-sensitive zone, my lord. So, I am not finishing.
Yes.
Lordship, kindly see the order dated, my lord, 6/2/2025, paragraph 9.
Yes, I have seen.
That, and then forest.
No, finally, 9/4/2025. Pollution Control Board is to clarify the stance of the Forest Department.
Yes, Lordship, we have to also file the affidavit as per the last order. We have tried to file today. The petitioner did not receive the copies.
Copy is not, why making this, this is very short, very unfortunate, my lord.
No, no,
I am
he's-
why this making
you
mistake?
say
I am
no,
not copy,
you say-
last night, my
You
lord,
say,
and my lord, and lord.
you say you have failed to furnish a copy.
No, he furnished.
Very wrong statement with me, my lord. I've never made it. And 38 years of pregnant, I never made this type of thing, my lord.
No,
This is the allegation, my lord.
No, not allegation, Lordship. That's why we
This
could not
is-
file today.
Counsel, my lord.
Why you are saying that he has refused to accept the,
I am not copying, not been, I have not been able, my lord. And
Lordship,
also-
we gave to his junior, I think.
No, I statement of a bar, my lord.
No,
And my lord, because of steroid, was not enjoying, my lord.
no.
Very unfortunate, my lord.
withdraw it, withdraw your statement.
Yes, I withdraw my statement. I am
You
sorry.
failed to, you failed to, you
Whatever
failed to, you failed to furnish the copy. That's why you
I am
could not
my
file.
lord. Copy is my
Anyway,
lord.
Anyway, Lordship, I am giving the copy right now.
he has withdrawn. his
I am
statement.
withdrawn. I'm sorry.
And lordship, I see, yes, I'm aware. And one occasion, my lord, he made a statement when
You
I'm
give it
reading
to-
the court. my lord.
You give it to the assisting council.
Yes.
Only to
Not-
my lordship,
not
I
the
see, my
senior
lord.
counsel.
Because we are today-
Anyway, if she is filing today, we'll see.
The only thing, Lordship, only for bearing for a moment, my lord,
No, once this court has on 9/4/2025, it's clearly recorded that the pollution control board has to clarify
Yes.
the stand of the forest department. All right, have you clarified that?
he appeared with a private party, man. He, my lord.
Okay, who is for the forest, the pollution control board?
None appear available.
And about the NGT? NGT report,
A report is there. And the report I enclose with the read petition, my lord. That I could not clear.
No,
The page 173, my lord, the read petition.
in fact, team from NGT has visited the area and submitted report.
Yes, my lord.
Team from NGT,
It is, I annex, my lord, in my read petition, my lord. It starts from the page 176.
NGT report,
Yes, my lord.
page,
We start from, my lord, that is, my lord, page 176, this is the order of the NGT. And my lord, the report, my lord, lordship fine at page 178, my lord, page 178. Internal paragraph 7, my lord,
178.
178, internal paragraph 7. It start from the joint committee now has submitted report by so and so. The NGT has formed a committee, my lord. They, after inspection, they submitted this report, my lord. It says the site was visited by the joint committee who found a number of brick lanes. And regarding, my lord, first one is my mind, that this is a brick lane. I have challenged, my lord.
It's okay, that is the statement. So now, do you have the report?
That's the report, my lord.
No, separate, who is the Goi? Who is for the forest department? You have made a submission on 9/4.
There's a joint verification report, Lordship. I have this.
Yes. The same thing. Is it the same thing as in 180, 178? Order of the NGT? Para 7, 178.
Paragraph
Not,
seven.
not that one.
It's not the same, Your Lordship.
Hmm?
Lordship, what has happened is forest department has themselves filed an affidavit in this case.
Who is pollution control board? There's a direction of this court.
Yes, Lordship, pollution control board has to clarify its stand.
Yes. What does report say?
Report is inaccurate. Yeah.
Lordship may have this report, Your Lordship.
Only one, Lordship, 184, my lord.
Hmm.
Kindly turn to page 184. And finally turn to 5, paragraph 5. That is the. How
The brick kills with
brick
zigzag
in with zigzag
technology and
technology
very
or vertical shape
vertical
for
shape
use of
or use
pipe
of
natural gas
pipe
as well,
natural
complying
gas
with the
as well,
standard notified by the MOC.
standard.
That is when so shall only be allowed outside the proposed ESDF, my lord. Brick can be, my lord, allowed provided it outside the ESDF, my lord. It is, my lord, the brick within, my lord, in the, my lord, default eco-sensitive zone, my lord.
This is by NGT.
This report is from the range of the Lordship produced here, not from NGT.
No, no. you see,
NGT report we haven't received yet, Lordship.
Huh?
NGT report we don't have received yet.
That is, we are talking about this NGT report only. That is the submission you made last occasion. In fact, team from NGT has visited the area and submitted report. Such report might have a relevance in determination of proceeding. Accordingly, he will produce the relevant report on the relevant person or the report before this call the next day. NGT report.
NGT report we have not received yet. Lordship.
Then
Fine. I have
what is
Lordship.
this report?
This is not the report, Your Lordship.
Huh? This is joint
Joint
verification
verification report.
by whom?
This is by the range officer.
No, it will not, it will not.
No, it will-
But
This is a different report, Your
Dilip
Lordship.
Chetty and joint verification influence of land covered by the in single and the status of land and measure the minimum distance. Yes, what does it say? It says falls outside the Pavitra Wildlife Sanctuary. What is the stand of the forest department?
But forest was there, my lord.
Forest saying that it's outside the wildlife sanctuary.
No, it is within the eco-sensitive zone, my lord.
No, forget about, we'll come back to the eco-sensitive zone. There's a report.
Yes.
Which he has produced right now, a joint verification report where it says Bhavani Brick Industry falls outside the Pavitra Wildlife Sanctuary.
Yes.
This is one report by the
No, they were,
Division Forest Officer.
forest has filed a report.
Now, he has, Mr. Gogoi has submitted on last occasion, and there's a report of the NGT.
That report I,
That is, that's
Yeah,
what I'm
yes, yes.
asking, I've seen it, whether this report which you have mentioned is,
You asked for the report?
no, is it, as that of which the Land Senior
That-
Council
that
has
I have to see
report?
Because we have not received the report yet, right? Because it is whether it's same as this or not.
And then 8, 9, 10 Pollution Control Board.
Pollution.
Fukan.
Actually, the Bricklin is under the MOEF guidelines of having a zigzag technology.
Ah.
So they are functioning as per the present norms which has been set by the MOEF,
Ministry of,
Ministry of Environment and Forest.
We have the zigzag technology, Lord.
Hmm?
We have the zigzag technology as per
It
the
is permissible.
permissible.
It is permissible.
Permissible.
What about the this eco-sensitive zone?
As regard that eco-sensitive zone, the forest department is in the right position to say as regard the area, whether it encompasses the forest zones.
No,
or-
no, they have
Because
already,
ultimately, we are giving the license based on the documents that they have submitted before the authority.
no, this forest department has clearly said that it doesn't fall under the wildlife sanctuary, Pavitra Wildlife Sanctuary, right? Now they have filed an affidavit. That's why I want to know, what is the exact, what is the stand, your stand? In the affidavit.
Produce the affidavit which we have filed.
Tell us, no?
This is that the issue of Bhavani Brick Lane located dock number 72 in Sangamari village, Maya, Muranga is was released in 2019. So in compliance with all of the directives, a committee was formed to assess the location of the point. As part of the assessment, the committee initially relied on the erroneous GIS based boundaries map, and based on the calculation, the brick lane was found to be 892 meters away from the boundary wall of Pavitra Wildlife Sanctuary.
800?
892 meters.
Huh.
However, a following joint verification survey conducted by officials from the Forest Department, Revenue Department, it was determined that the actual physical distance from the revised boundary is 1200 meters. The previous discrepancy arose due to errors in the GIS based KML map, which has position inaccuracy. Joint verification report confirming this is the next option. So now basically from 893 it has gone to 1200 meters or not.
Away.
My lords,
You
I
are
have to-
pollution control.
I
Board.
have to add something, my lords.
Are you for?
Yeah, Forest Department, my lords. I was on the way. He is my colleague.
No, no, it's okay. What about the?
But the issue is pending with the Supreme Court. There is an exercise to demarcate the boundaries. My lordship, I'll pass an order sheet dated. Order sheet dated, my lords. No. 19.3, my lords. 19.25. The relevant paragraph is page 27.
Fukon is for pollution control board.
No, I'm for the Forest Department.
No, Fukon.
He is, no, Borua.
Borua, who is for pollution control board?
I'm
He is for the,
Yes. You read you find out the stand of the forest department. Yes.
well, can see the additional Advocate General Alan N. Kohli, my lords. He appears before the Supreme Court and says, there are some
Process
exercises
of
going on.
Demarcating the boundaries of Pavitra Wildlife Sanctuary under active consent. The matter was referred to the.
Government a proposal
Means we.
No.
Come up with. Yes.
This is again listed, directed to be listed on 21/5 of this month.
So it was concrete, something concrete supposed to.
Yes,
come
my
up.
lords.
Anything? Every
After
item?
20, after it is fixed on 21/5, my lords. Today is,
No. Submits that something concrete would come up by end of April.
end of April. And my lord, the direction is passed by the Honorable Supreme Court to list this matter on 21/5.
It's okay, we understand, but I'm just asking.
Oh.
Since your, the lawyer has already said that the concrete, something concrete will come out
Yes, my lord.
by end of April, anything?
Not, till now, I have no information, my lords, but something is going on. We are proposing to submit something before the Supreme Court, my lords.
This is same area
Same area, my lords, same wildlife sanctuary, my lords.
in both the.
Yes,
petition-
yes, yes, this wildlife
Both the
sanctuary. Yes, my
petitioners.
yes.
Proposal submitted, my lord, is not decided. In that case, my lord, 10 kilometer, as per Supreme Court judgment, my lord.
No, no, that will, merit will see, because,
And they
The-
did
the-
stand also. They stand also.
the forest department says that it doesn't fall under the wildlife
Because-
sanctuary.
No.
But in case, in view of the Supreme Court decision, judgment, the stand of the forest department
Yes, madam.
with regard to, including with regard to the eco-sensitive zone,
Yeah.
the pollution control board has to take a decision, I mean, to clarify whether it is, it can be permissible permissible or not.
Permission, no, what to do?
It is permissible.
No, no, no.
Is it permissible?
Yes, a permission.
It-
It is
it
not
doesn't
permissible,
come.
but
It doesn't-
my lord, my lord, it is not permissible, but in the proposal, there are certain kind of activities, my lord, outlined. My lord, prohibited, regulated, my lords. This is prohibited, my lords.
So how
The
is
ENZ.
pollution control board saying that it is permissible?
No, no, I didn't get, actually, I was trying to figure out what has been passed in the last order. Because ultimately, we are basically.
I'll just tell you. The pollution control board shall clarify their stand in respect of the stand of the forest department. What is the stand of the forest department?
Our report is very clear. Our stand is it falls within the 10 kilometer, my lords.
Huh?
Within the 10 kilometers, my lords. Within the 10.
This-
Proposed ESZ instead.
This
Yes, madam.
brick
One-
kiln.
194, my lord. Their affidavit is
Just wait, sir.
10 kilometer radius হলে নহব।
It has found that the Bhavani brick industry falls outside the Pavitra Wildlife Sanctuary.
Logic allows me to submit.
Just wait.
It is way to run. 194, page 194.
Because now their conclusions that they have drawn that previous recorded distance of 892 meters, that is page 194, was due to geospatial inaccuracies in the earlier GIS based map. So now the distance criteria, if at all, it is to be determined at 1200 meters from the revised boundary. Then we have to again revisit the thing and we have to find our own final report. So for that matter, I should be given some time to file my affidavit.
That's why,
I
that's
will
the
clear the
reason.
stand in my affidavit.
Sir, that's the reason on 9/4, they were given a chance to clarify.
এখন copy
Yes.
almost 1 month, my lord.
Then when sir released after 21st,
My lords.
list after, so let us see.
No, only thing, my lord, yes, my lord. Lordship.
Supreme Court is in
Your lordship, you will
decision
give
of the matter.
No, I think lordship, my lord, only for being for moment, my lord. This issue is going on since 2012, my lord. In the
It's okay,
the eighth round of litigation, but only my lord, brief period, my lord, allowed to my lord function on the last year, 1 month, and this year from 1912, my lord. Only thing, my lord.
So
is
it's a matter
and
today-
my lord, that
today
there is a, my lord.
today
there-
is 6, sir, only 14 days,
no, only
15 days. Will
Only
attend
thing,
the
my
matter.
lord, only thing, my lordship, can in that case, my lord, that my operation will be stayed, my lord, because lordship follow down that what.
No, no,
is that- please, please, please. My lord,
Operation
what
stay.
is regarding, my lord, state, because whether it is a case of balance of community there, whether it is irreparable loss and a prime MC case. But in this case, my lord, lordship kindly see, if there is a order from the division of this court, will stated then, my lord, if briefly is allowed to, my lord, operate, whether it affect the my lord, surrounding land. And my lord, pollution control is silent, whether it affect only they have to tell the other thing we follow, they allow to. But whether or the impugner has not said anything, whether it affect the surrounding land, my lord. That is the last occasion whether matters came up before Resolution 6 to paragraph 9, it clearly stated. It to clarify whether police will clarify whether it affect the my lord surrounding land. That is that we are the agriculture, my lord. Our land has been, my lord, because of the brick in, my lord. We cannot, my lord, cultivate the land, my lord. This is one of the issue, my lord. The poor people, my lord. Kindly see, my lord, order, paragraph 9 of the order dated 6/2/2025. Then, my lord, whether it is affect the surrounding
Have you
land.
seen this order?
Yes, no, I've seen, my lord. And my lord, and forest government stated, my lord, in their affidavit, my lord, kindly see, may I read, my lord, allow
Just
me.
tell us.
Therefore, therefore, although the Bhavani Brick is now determined to 1200 meter from the revised boundary, it will still fall within the default eco-sensitive zone of Pavitra Wildlife Sanctuary and remain subject to applicable environmental regulation. In light of the revised boundary verified, what my line says, eco-sensitive Pavitra is remain applicable in accordance with the Honorable Supreme Court directive. What the Supreme Court has said, my lord, till the finalization of the eco-sensitive, my lord, boundary, my lord, 10 kilometer will be considered as an eco-sensitive zone. That order has not been, my lord, verified. It is clearly against that apex for judgment, my lord. What my learned friend state, it is the stand of the forest department also.
Where is the affidavit?
That
Page
There, page 194, my lord,
194.
forest department, my lord. Page 194, paragraph 4, my lord. Eco-sensitive zone of consideration. As your last got it, page 194. As the boundary of the Pavitra Wildlife Sanctuary remains sub judice before the Honorable Supreme Court in IN number so and so and so and so, the eco-sensitive zone has not yet been officially notified. However, as per the Honorable Supreme Court order dated 11/12/2018 in WC number so and so, a default ESZ of 10 kilometer applies from the sanctuary boundary. Therefore, although Bhavani Brick Lane is now determined to be 1200 meter from the revised boundary, it is still falls within the default eco-sensitive zone of Pavitra Wildlife Sanctuary and remains subject to applicable environmental regulation. It is not within the eco-sensitive zone. The order has not been. This is against the clear violation of Supreme Court order, my lord.
That is my case. That in 2018, Lordship will kindly look, that is dated 11/12/2018. After 2018, the Supreme Court modified this order in 2023. And that order has found its place in the order of the Honorable High Court. And in the affidavit that I have filed to their Lordship, I have annexed all the orders. That order of 18 has been modified. Now 10 kilometers have been brought down to 1 kilometer. In the same proceedings,
Ian Gadabarman.
Yes, Lordship, same proceedings.
Latest order. Which
Yes.
order? Which order?
Yes, Lordship, this is my affidavit.
No, which order?
It's an order dated 26/4/2023. In TN Godavaram versus, it is reported also, 2023 SCC online 504. That has been modified and
No,
that,
Not the affidavit order.
Page number.
page number, yes, Lordship, page 290, 260. None. Both orders I have annexed.
Era?
Yes, Lordship. Firstly, Lordship will come to para 27. Then 27. The Supreme Court mentions this order also. That Lordship has just page 27 to 75. All orders that they have mentioned, the next relevant order would be order dated 11/12/2018. It will be relevant to refer the following part of it. Lordship, the order is referred here. At page 276, all the orders it is referred. Now, Lordship would see at page 65, para 65, at page 292. It starts from para 60.
Huh?
Para 60, Lordship.
Hmm.
Para 60 and 65. Insofar as the restriction of mining is concerned, we are of the considered view that it has been consistent view of this code that the mining activities within an area of 1 kilometer of the boundary of protected area will be hazardous for the wildlife. Though in the case of Goa Foundation, the said direction were issued in respect of state of Goa, we find that such direction needs to be issued on pen India basis. Now, at para 65, Lordship, the final direction. It is modification of the earlier order. We also modify the direction at 56(4), Lordship. That order is also annexed in this affidavit. Order and direct that mining within the National Park Wildlife Sanctuary within an area of 1 kilometer from the boundary of such National Park and Wildlife Sanctuary shall not be permissible. Therefore, initially, because proposal was not same, it was to make in Lordship, in what it was made 10 kilometers, but subsequently it has been modified. And this order finds its place in the order of the Honorable High Court. That is annexed to this petition. Lordship, now, now Lordship would see in this petition, the order starts from, the earlier order of this Honorable starts from 100.
It's okay. We'll take it up, list after 21st.
Yes.
Only thing, my
Simply
lord,
okay.
yes, my lord,
Mr.
my learned friend, my lord, referred to my lord, their modification, but my learned friend referred, my lord, their modification.
Sir, we'll
of the-
consider
no,
everything.
paragraph-
Let the affidavit be brought.
No,
up.
learned friend, my lord, says, but there a modification of paragraph 56. But regarding 50 Supreme Court direction in 56(8) has not been, my lord, modified. Can you see, my lord, that is the my learned friend referred to the judgment. It modification in so far paragraph 56(2). But can you see 2022, my lord?
Okay, we'll take it up, sir. We'll take it up. Take it up.
Only thing, my lord. only
Issues
thing-
are being taken care by the Honorable Supreme Court. And they have made a statement that something concrete will come out by the end of this month, April. So
No, no,
matter
no,
has
yeah.
been listed on 21st of this month. It's a matter of 15 days.
No, only thing, I'm
If
giving time.
nothing, if nothing happens, we'll consider your prayer.
No, only
Because
thing,
it's a matter of pollution only, so we'll consider that.
no, only thing, my lord,
Subject to what Supreme Court had said.
no, only thing, my
Who
lord,
would say?
no, what might tell, my lord, what might tell, Lord, submit before your lordship, my lord, question of giving time is, I don't know, my lord, I know this, because this matter is pending, my lord, since 2012. The only thing, my lord, that is, my lord, that regarding that a request into 10 kilometer is still in force, my lord, and my 10 kilometer radius is still in force, because what my learned friend referred, it's the modification of Supreme Court saying 56(2), but direction is 10 kilometer 56(8). 58, 10 kilometer has not been modified. That is not been modified. Can you see, I refer to Supreme Court judgment. For the 56(8.8) has not been modified.
We'll see. We'll see.
Only thing, my lord,
It's a
that-
matter of
well,
15 days.
My lord, last time we given, my lord, I whatever may go, my lord, because I want to resolve, my lord, because people are suffering,
yes.
my lord.
Okay. It's one more concern than your personal interest.
And my lord say, only my lord say, only can you see? And my lord say, and my learned friend, he himself is NGT case. What is submission? Can you see? Where the council order, that NGT order dated 29/4/2025. My learned friend say, my learned friend appeared. The council order respondent informed the matter relating to the Povitra, that NGT order. Povitra Wildlife Sanctuary and demarcation of the boundaries pending consideration of the Honorable Supreme Court in IN number so and so. He stated by NGT regarding the demarcation is pending. My learned friend stated the NGT, my lord.
No, that is a fact.
That is the order, my lord.
No, that's the
NGT
fact.
order. That is the order for NGT, my lord. That's the
Sir,
order for NGT.
Sir, that is the,
my lord.
sir, that is the fact. It's pending. It has not been.
I normally I'm not insisted, my lord.
Yes, yes.
Can you give me the date, my lord? So,
Heard Mr. Question. Arborua. Learned senior counsel, assisted by
NM Datta.
NM Datta, learned counsel for the petitioners. This court, having considered the state of the forest department on 09/04/2025 as directed, the State Pollution Control Board, I respond number 8, 9, and 10 to clarify their stance. Mr. It also, it has, it has further directed Mr. D. Gogoi, the Standing Counsel for the Forest Department, to produce the relevant person or the report of the NGT with regard to the NGT. Today, Mr. D. Gogoi,
My lord,
Learned Counsel for the Forest Department. You don't have the report, NGT report.
my lord, it is in office, my lord. The panchayat elections, my lord, they couldn't furnish it to us. Otherwise, I have the report. Soft copy is there.
Every day Panchayat election,
My lord, soft copy is with me.
on the ground.
I need
is
the
every
official
day
copy.
present. Submits that, although he has received the
From the
report.
Business.
Come on, he has not brought the same to the court. Mr. Fine. He further submits that the process of redemarcating the boundaries of the Pavitra Wildlife Sanctuary is under active consideration, as can be seen from the submission made by the learned senior counsel appearing for the state of Assam, Mr. Nalin Kohli, before the Honorable Supreme Court in the case of
This is TN Godavar,
T.N. Godavar, Indra T.N. Godavar.
WPC 202 of 2019, 1995.
In red position within bracket S, bracket close, bracket, within bracket civil, bracket close. Numbers 202 of 1995. The matter has been referred to the State Board of Wildlife as well as the Ministry of Environment, Forest and Climate Change. Therefore, something concrete will come out by the end of April 2025. And on the adjournment of the Learned Senior Council appearing before the State of Assam, the matter has been adjourned to 21/05/2025. Next matter. Although the Learned Senior Council for the petitioner has vehemently urged for passing of the interim order, having considered the fact that the matter is in the season of the Honorable Supreme Court in the case of in a T.N. Godavar, Sufra, and that the and considering the state categorical statement of the Learned Senior Council appearing for the state of Assam and the as well as the submission of Mr. D. Gogoi, London State Council, the London Standing Council for Forest Department. Come on, the method, let this method be listed after 21/05/2025. Mr. Private Respondent.
BP Bora.
BP Bora. BP Bora, Learned Council, appearing for respondent.
Respondent.
No, accordingly, list this matter on when? After 21?
Any date, man, after 21.
27/04.
27.
Not 27, any day, any before, any.
26. 26/04, 05/2025. List of. In the meantime,
Human Authority, Mohammed Authority.
Learned Council, Mr. BP Bora,
In a 27.
For the
Can
respondent
you number
number,
27?
respondent number
12.
12 may file his response.
Can you not 27, my lord? The Tuesday?
27.
He has some difficulty.
There are only 27, any day.
29 kilo.
29.
29.
Keep it in.
Board of 29.
Here.
How much?
This matter, your lordship, pertains to grant of financial assistance
Yes,
to the venture education institution in the state of Assam, wherein the similarly situated venture schools, they have been granted the financial assistance, depriving the petitioner schools, and hence petitioner
Yes.
schools approached the Honorable High Court. And Honorable High Court, your lordship, has disposed of that matter with a direction to consider the case of the petitioner in accordance with law. Your lordship may kindly see the order. May I take your lordship?
and accordingly, the authority has passed an order.
Yes, on last date, yes, your lordship, on last occasion, the
Where it-
order is at page, your lordship, I take your lordship to that, yes, page 85, 86, your lordship, annexure M,
86.
86.
The order by the honorable, certain school mentioned are entitled to receive financial assistance for the. Secretary to the Government Assembly, yes. Nothing remains.
Lordship, but Lordship will consider the affidavit that we had filed, your
No, it's
Lordship.
okay. What do we, you have passed an order that they are
Lordship.
entitled.
86 we have.
How it
filed.
can be disowned? Page 86,
86 I have seen, your Lordship.
so. You consider and grant it in terms of the, as per the rules or what?
Rules,
As per previously, it was rule, your lordship.
Lordship, in fact, the rules do not allow to give financial assistance.
So then why you have said so?
Lordship.
And Supreme, High Court has also said so.
Lordship, because this was, the assistance was given under a scheme, your Lordship, and that scheme was
No, we're
stopped.
not going to all this.
Lordship.
Your secretary to the government of Assam
Lordship.
has passed an order saying that they're entitled.
Lordship.
Right?
Yes, your Lordship.
No way.
And the affidavit that we had filed, otherwise, it
Saying
says
what?
other. Yes, your Lordship.
And even your lordship
How
may
can
take
you
your,
pass an order saying that they are entitled and you are by our affidavit, how you can
Lordship.
object to it?
even your lordship may kindly have a look at page number 93 also.
Because you cannot, it's all right.
Yes.
The High Court has already said that they are entitled. So you have passed it. You have not filed any appeal. You could have filed an appeal saying that no. As per the act, all the rules,
Lordship.
they are not entitled. Therefore,
Yes, your Lordship.
and you have not filed any review also.
No review has been, no
But it
appeal.
has
no
filed,
review.
I think final appeal.
They have clarified, your lordship, that no review and appeal lies, your lordship, page number 93. Even
No
in page
review
number
or
93.
appeal
your
lies?
lordship.
In
In
the
page
sense-
number 93.
This was the opinion of the
This
Advocate
was the
General.
opinion of the senior standing counsel. Page 93.
No, we're not concerned. Admittedly, there is no appeal, no review.
No.
No.
So-
They have admitted also, your lordship.
Everyone's hands are tight now.
Lordship.
So we'll allow.
Lordship.
Heard Mr.
P. Sharma.
P. Sharma, learned counsel for the petitioners. How many petitioners?
Altogether,
13.
10.
And also heard Mr. MS
Hmm.
D. Musahari,
Lordship. Lordship.
learned
Dean
counsel
Musahari.
for the
Secondary education.
learned standing counsel, secondary education, government of Assam.
Finance is also here, your Lordship.
And Mr.
Is.
H. Elia, learned counsel for the learned standing counsel, finance department. Correspondence, you find out who else. Next para. By this is the third round of writ petitions. Third round of writ petition by the petitioners seeking financial assistance
এটা দেখছেন তো মনে করে
to the petitioners' schools.
তোমার তোমার নোটশিট লাগাইছে নোটশিট আছে
For the year 2010 to 11, 2012 to 13, and 2013 to 2014. Under what rule?
That was financial scheme, your lordship, under,
Under, where is that?
yes, that is, yes,
As per the, huh?
yes, that is, your lordship. Annexure,
Tell,
annexure, annexure B1, page number 51.
Where is someone?
And forwarding letter is annexure B 49.
As per the guidelines for implementation of state plan scheme within FSTOT, financial assistance to the venture education institution. Page 51, huh? Mr. The case of the petitioner, in nutshell, is that petitioner schools are situated in different districts of the south and are all venture schools. You are recognized. You are recognized
no.
schools.
No, your
Venture schools, your lordship, these grants are given under this scheme actually.
Okay.
These are venture schools.
non-government schools. your
Non-government school,
lordship.
No, it's a recognized school.
recognized, otherwise.
It's a venture school.
Yes, venture.
Venture.
Please stop. The and the schools are the schools are recognized as venture school. Please stop. The next para, huh? The government of Assam had introduced a state plan scheme for the year 2010 to 2011. Namely, within FSTOT, huh? Scheme for financial assistance to the venture education schools in the state of Assam. Mr. As per the terms of the said scheme, the petitioner schools are eligible to be provided with the financial assistance, Mr.
Sanction the police 149. 13 school grade 9.
The petitioners approach the respondent authorities in terms of the above scheme. However, on being not granted, the petitioner approached this court by filing a writ petition being WPC 4787 of 2011. Where is that order?
Yes.
Where is that order?
Yes, that order is at page. Let me take your lordship to that order, page 59.
59. Ah. This is the first order
Yes,
for consideration.
for consideration.
Mr. This court on 29/02, by the order dated 29/02/2022. Not by this court. By an order dated 29/02/2012. Has disposed of the writ petition. And as agreed to by the learned counsel with the parties, directed the respondents to look into the grievance of the petitioner and pass appropriate orders in accordance with law. Mr. Thereafter, it was rejected.
No, it was followed to some extent. 2-3 letters were issued, but somehow surprisingly, an order has been issued.
Where it is,
Yes, or that is annexure A, page 67.
rejecting your claim.
Yes, rejecting. But prior to that, they have issued certain order in my.
It's all right, forget
Okay.
it. This is the ultimate order.
Yes, this ultimate.
Which one thing. The Director of School Education, Assam, by the order dated 14/12/2012. Considering, has where is this? This is not rejection.
There it said that, only
Action will
second-
be initiated as soon as necessary instruction on the matter received.
yes. This is para 5, as per the guidelines, only those secondary school. Junior colleges, which,
It was not rejection.
yes,
They sought for an, by so and so. Director, by so and so order dated, 14/12/2012.
can you see the second pair of that order? As per the above guidelines, only those secondary school junior colleges which receive financial assistance during 10-11 shall only be eligible to receive financial assistance
Okay.
for a year 12-13.
Has rejected the claim of the petitioners on the ground that as per the guideline, only those secondary schools, junior colleges which received financial assistance during 2010-11 shall only be eligible to receive the financial assistance for the year 2012-2013. And as the petitioner institutions did not get financial assistance during 2010-2011. As per the government guidelines, for extending by financial assistance cannot be considered by the Director of Education, School Education. Mr. However, a letter has been sent to the government seeking instruction on the matter. Next paragraph. Against this order,
Yes,
you have
yes,
filed a
yes,
petition. again.
Annexure I, next page, page 68.
The petitioner school, the petitioners have again have filed second writ petition being WPC 5386 of 2013.
Operative portion, Your Worship, may kindly see from page 73.
Against you have filed this petition against the rejection,
Yes, yes.
against the rejection of the claim of the petitioner for financial assistance by the Director of School Education dated 14/12/2012, right? List of discord. By an order dated 10/04/2014. Where it is,
That is
has
page,
disposed of the
page 73,
Above
bottom
that.
portion.
writ petition. By directing the respondent authorities to provide financial assistance to the schools in, to the petitioner in schools. Now you are 10, this is 13.
Yes,
At present, you are 10 schools.
yes, at present 10.
Earlier,
Earlier
it was 13.
Yes,
Schools in question, the assistance to the 13 members of the schools, including the petitioner. For the year 2010 to 11, as well as also for the year 2012 to 13. And such benefit must reach the petitioner within an utter limit of 4 months from today, 4 months from the date of the order.
and then your lordship, page 86.
80, then 86. Next para. Pursuant thereto, pursuant to the order of this court, dated 10/04/2014, passed in WPC 5386, public 2013. The Secretary to the Government of Assam, Secondary Education Department, by the order dated 08/12/2014, has decided issued the order whereby the 13 schools mentioned in the writ petition, mentioned in WPC 5386 of 2013, including the, within bracket, including the petitioner herein, petitioners herein, bracket close, are entitled to receive financial assistance for the period 2012 to 13, and necessarily 13 to 14, 14 to 15, as they received recognition in 2010. Mister. Then what is your submission? Mister,
No submission, your lordship, whatever your lordship has read,
no,
the order, your lordship.
Mr.
P. Sharma.
P. Sharma, learned counsel for the petitioner, submits that despite of the clear order of the secretary to the Government of Assam, Secondary Education
Secondary
Department, dated 14, what is this?
Date, dated 10th of December 2014,
8/8/08/12/2014,
8th of December 2014. Yes.
The petitioners have not been provided with the financial assistance in terms of the assistance till that. Mr. Therefore, he submits that his simple prayer is to grant the financial
Yes,
assistance
assistance in view of this order.
as per the order of the honorable order of this court in WPC 58 something, that one, second last, and the consequential order passed by the Secretary to the Government of Assam, Secondary Education Department, dated 08/12/2014,
Outer time limit may be framed, your lordship.
within time frame, within a reasonable period of time, within a reasonable period. Listen. Next para. Mr. MS. D. Musahari,
Lordship.
Learned Standing Council for the Learned Standing Council for Secondary Education
Secondary.
Department. Well, while referring to the both of you are saying that as per the new act, they are not entitled. It is barred under. What is this? Your statement.
Lordship,
Yeah.
Lordship, is that paragraph 6, your Lordship?
Hmm.
Lordship, in fact, earlier 2011 Act also, they were not eligible, your Lordship. And under the new Act also, they are not. And how this, because it was a policy decision taken by the government, your Lordship. Paragraph 6 and
2011
paragraph 7, your Lordship.
Yes, you write paragraph 6 and page
And 7, your Lordship.
107. Submits. Well, I'll record your name also. Both D. Musari and and Mr. N. Salia, London State Council, London Standing and Finance Department have submitted that.
Thousand 11 Act that was declared, your lordship, unconstitutional.
In view of the subsection 6 of section 3 of the Assam Bencher Education Institution within bracket provincialization of services bracket clause act 2011 now repealed, bracket clause which provides that 7 except the institution established and maintained by minorities under Article 3 of the Constitution of India, which is already getting some financial assistance or grants in aid. No private or non-government school education institution shall be entitled to get any aid or assistance from the state government in any form with effect from the date of coming into force of this act,
Similar provision is under the new Act, your Lordship.
which has been provided, a similar provision which has been provided in the, where it is,
1, 4. Under section 3, subsection 9, your Lordship.
under section 3,
Section 3, 9, subsection 9.
under subsection 9, section 3. In the, what is that new act?
The new act is, your Lordship, the Assam Education, Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017.
Where do you get it?
Page 5, your Lordship. Lordship, sorry, your Lordship, paragraph. Page 5
Page 5.
of my counter affidavit, your Lordship.
The Assam Educational Provincial within bracket Provincialization of Services of Teachers and Reorganization of Education in Act 2017, page 119. The petitioner schools are not entitled
Not.
to be entitled to any financial assistance. As the claim of the petitioner is not under the act or rules or under any acts or rules, rather a policy, rather a guidelines which has been issued by a policy decision of the state.
Lordship.
The enactment of the act, above act, would render the guidelines, they render the guidelines of the guidelines of the decision of the state redundant. Next paragraph. Please step. However, the Learned Standing Council have fairly submitted that no appeal or review has been filed against the judgment and order dated page, what is that?
Yes. Page, your worship,
Order dated 10/4/2014.
8 December 2014. 86.
High Court order.
Oh, High Court order. Acha, okay.
10/4/2014
10/4/2014.
passed by the High Court. Passed in WPC 5386 of 2013. Please stop. I've considered the submissions of then counsel to the parties. Also peruse the materials available on record, including the judgment in order dated 10/04/2014. Passed by this court in WPC 5386 of 2013. This court on 10/04/2014, next para, huh? In WPC five three eight six of 2013, Supra, huh? Wherein 13 writ petitioners consisting of high schools. Yours is also high schools.
High school.
Private, the
Yes,
venture,
Venture size.
venture high schools in the state of Assam, including the present petitioners. After consideration of the entire matter, has directed the respondent authorities to provide financial assistance to the thirteen high schools, including the petitioners, for the year 2010 to 2011, as well as also for the year 2013, 12 to 2013. And such benefit must reach the petitioners within an outer limit of 4 months from the date of the order. It's the person thereto, the Secretary to the Government of Assam, Secondary Education, Police Kabha, before that, next parent. The undisputably, no appeal or review has been filed by the state respondents against the state judgment and order that is 04. 10/04/2014. Judgment, huh? Order, huh? And which is clearly admitted by the council, extending council to the respondents. And the same has attained finally. Next paragraph. Admittedly, pursuant to the above order dated 10/04/2014, passed by this court, the Secretary to the Government of Assam, Secondary Education Department.
Department of School Education, Your Lordship.
Secretary to the Government of Assam,
Department of School Education.
will say Secondary Education Department.
Now it is Department of School
Department,
Education.
same, Department of
Same, Your Lordship.
Secondary Education.
Lordship.
Will say what is in on record.
Lordship.
Secondary Education
Lordship.
Department
Lordship.
has issued the order dated 08/12/2014. Whereby the 13 schools in the said writ petition and the said writ petition C5386/2013, including the present petitioners, to be entitled to receive financial assistance for the period 2010 to 11, 2012 to 2013, 2013 to 2014, and 2014 to 2015, as they have received the recognition in 2010. Mr. On 2020, the Learned Standing Council for the Secondary Education Department. Now, for the Department of Secondary Education has fairly submitted that other than the order pursuant other than the order passed by the Secretary to the Government of Assam, Secondary Education Department, that is 08/12/2014, pursuant to the order of this court, there is no order and no financial assistance
No, paise.
has been granted to the petitioners.
Oh, 8.
Having considered the submissions of Learned Council to the parties, and also in view of the fact that the order of this court dated 10/04/2014 passed in WPC so and so 2013 has attained finality, and the Secretary to the Government of Assam, Secondary Education Department has issued the order dated 08/12/2014 to the effect that the petitioners are entitled to receive financial assistance for the period from 2010 to 2015, and if they considered be that no issue, there's nothing, no issue is to be, no issue remains to be determined as to the entitlement of financial assistance to the petitioner. The authority in the Department of School Education, Secondary Education, having been passed the above order dated 08/1/12/2014, holding that the petitioners are entitled to receive financial assistance for the year 2010 to 2015, pursuant to the order of this court 10/4/2024, dated 10/4/2024. The this writ petition is disposed of with a direction to the responding authorities to provide to grant the financial assistance as admittedly entitled to, as admittedly no, provide the financial assistance, grant financial assistance for the period of 2010 to 2015 within a period of 4 months from today. 4 months from today.
4 months, Your Worship.
Will not say what the next, whatever is has been held here, 2010 to 2015. We'll say that's all. If we say as per the rules or act, then
As
it
per
will
the act,
create a problem.
Financial assistance cannot be given, Your Lordship.
So we cannot,
Lordship. And the scheme was in fact stopped in 2011, Your Lordship.
no. You have said
Lordship, but we have-
2015, you said till
Lordship,
2015, they are
Lordship,
entitled. How can
Lordship.
that be stopped?
Lordship.
The representatives. Representatives. Disclosure.
Lordship. Oblige, Your Lordship.
The mobile.
Yes,
May I please? All right. Initially, in this case, I was appearing for respondent number 5.
yes.
Subsequently, sometime in 18, the matter was dismissed for default of the learned council.
That is when.
Thereafter, a new set of council engaged
Hmm.
and they have filed restoration, it was restored. So after dismissal in 18, I have returned the brief, madam. So I am now not in this case. My name is shown in this case. And more particularly, I have shown the earlier set of council's name is appearing. The name of new set of council is not also appearing in the,
Who are the new sets of council? It is
That
their
matter-
duty.
some SB Loshkar is there.
Will dismiss for default.
Earlier 18, sometime in 18, it was dismissed for default.
know.
So at that time, I returned the brief to my client.
Non appears for the petitioner on call. State also not nobody is appearing. State is a party.
Yes, it's the party.
State is the party.
Against the revenue board.
Revenue board judgment.
State is a party.
Yes.
Yes. Lord appears for the petitioner on call. And also for tribal respondent number 3, 4, and 5. List of Mr. Vijay Talukdar, next para, additional senior government advocate, who is present for respondent number 1 and 2. 1 and 2. For respondent number 2. Then in that case, no appears for the respondent number and respondent number 1, 1 and respondent number.
My submission will be recorded.
Your name is not, you are no longer.
In the cause list, my name is there, therefore.
Huh?
In the cause list, my name is.
Unnecessary will not. 1, then in that case. This is petitioners, Non appears for the petitioners, as well as for respondent number 1, 3, 4, and 5, Then Mr. Vijay Talukdar for respondent 2, This writ petition was filed way back in 2012 and was dismissed for default on 29/01/2019. On the application of the petitioners, the present writ petition The same was restored by the order dated, by an order dated 04/04/2025 by this court. The petitioners and non-appeals for the petitioners, even after restoration of the writ petition, which is pending, which was filed, and way back in 2012, and dismissed for default on 29/01/2019. It appears that the petitioners are no longer interested to pursue the matter even after restoration of the writ petition when allowed. Accordingly, writ petition is then dismissed for non-prosecution.
Apply.
May I please your lordships?
Yes.
I'm seeking a short adjournment, my lord.
Huh?
For 2 weeks, my lord. I
Why?
could not prepare the brief to argue the case today.
What's there?
The
That
matter- The matter is,
recovery, what is that order has already been passed?
my lord, the order was passed, my lord, the order is at page, my lord,
This was of the
170.
OA.
Yes,
OA has been disposed of.
no, my lord, during pendency of the OA, my lord, there was an application under Indian Evidence Acts, which was allowed
It's
for
all
secondary
right.
evidence.
You
my-
challenge the order.
The
You
order
challenge
was
the
challenged.
disposal.
Yes, my lord. The order was challenged, my lord, before your lordships, and there was an
No,
order.
that was during the pendency of OA only.
Yes, my lord.
Original
Now-
application.
Yes, my
Now, during the pendency, original application has been disposed of.
Yes, my lord. The original application was disposed of after the order was passed by this honorable High Court, my lord. That is at page, my lord. Order dated 8/1/2016, my lord, may be seen. 8/1/2016, my lord. Passed by this honorable High Court, my lord.
8/1,
2016, my lord.
where it is.
8/1/2016, my lord.
Ah. Final order, but the same is made subject. to
Yes, my
review.
lord. The final judgment which is passed in the OA was made subject to the outcome of this writ petition, my lord. Now, this writ petition was preferred only of the fact that
Have you brought on record?
my lord.
Have you brought on record the disposal?
No,
My
no,
lord,
that is
I-
there. We have filed an affidavit, we affidavit the judgment in favor.
You have brought
We have
it.
filed
Yes,
that-
we have put out on record.
Then it's okay. So that to be, in that case, in view of this order 8/01/2016,
my lord.
it has to be decided.
Yes, my lord. Yes,
Let it be decided.
So,
only my lord, I just short accommodation, my lord. So I can,
16 matter, why, what sort of documents? Huh?
if your lordship, then I'll just argue the matter today only, my lord.
What are the grounds?
My lord, I'll just give the brief background of this case before I go into the grounds, my lord. What had happened in this case, my lord? The OA was filed by the respondent bank, my lord. And we appeared before the learned DRT. We filed our written statement, my lord, therein. And then evidence on affidavit was filed by the bank, my lord. And we filed our counter affidavit. And the matter proceeded for final argument, my lord, in this case. At the time of argument, my lord, after submissions which were made by the bank, while we were making the submissions, we have stated that the original general power of attorney was not proved in original, my lord. Neither that was given through an primary evidence nor as a secondary evidence, my lord. When the matter came therein, my lord, the bank took some time to file certain applications, my lord, before the learned DRT, my lord. On the next date, my lord, 3 applications were filed, my lord. First application was filed for amendment of the original application,
It was allowed.
it was allowed, my lord.
Then
And secondly, two applications were filed, one for the production of the original general power attorney, my lord, and second application for secondary evidence. My lord, we filed our objection to that effect. And the order was passed wherein the amendment application was allowed, my lord, and two of those applications were withdrawn by the bank, my lord. Both the applications being for the primary evidence and the secondary evidence was withdrawn, my lord. On the next date, when the matter was fixed again for the argument, again two applications were filed before the learned DRT, my lord. And in those two applications, one application for the secondary evidence was allowed, my lord. And by way of this writ petition, my lord, the petitioners have challenged that order which was passed wherein the secondary evidence of the general power attorney was allowed, my lord. Now, the grounds on which we have come before your lordships are one, my lord, this secondary evidence application which was filed, my lord, is barred by constructive res judicata first, my lord. Because earlier, once they filed the application, they withdrawn it, again they filed another application in the same suit, my lord. Secondly, my lord, we have come before your lordship saying that while the commencement, before the commencement of the trial, they ought to have filed the application. But they have not filed the application for allowing them to produce the general power attorney by way of a primary evidence.
amendment.
No, my lord, the application to allow them to exhibit the general power attorney through primary evidence or secondary evidence that ought to have been done at the time of commencement of trial or before the commencement of trial. My lord, the matter proceeded for final arguments, my lord. At that stage, they came up with that application.
Where is the bar?
My lord, because
Under which provision it is barred?
my lord, I have a humble submission to that effect, my lord, that the commencement of trial is an important
Under
stage
what
because
provision?
I could not have replied to that because they filed their
What
evidence.
is the provision that, under which provision it is barred?
It is not directly barred, my lord. I'll not say that it is directly barred, my lord, but since they have filed evidence on affidavit, I filed my counter affidavit.
That's why I'm asking, what's the bar, specific bar under the law?
My lord, there is no specific bar, my lord.
Then, if it is not
that
bar-
can be considered, my lord, but point is this.
While disposing of the OA, original application,
My lord,
has it caused any prejudice?
yes,
to you?
my lord. That has caused prejudice, my lord. Maybe
Has
please
it-
to see.
Has
But
it
they-
helped the opposite, I mean, the applicant?
Yes, my lord. My lord, may you please to see the order which was passed by the DRT on 17/7, my lord.
No, forget about that.
On
Well,
143, my lord.
Where on that? I'm just asking in view of the disposal of the OA, whether these things has prejudice to you.
Because, my lord, here in the petitioner number 2 is a power of attorney Gulder only, my lord.
No, that's what I'm
So
asking.
that's why I'm prejudiced, my lord, as far as petition number 2 is concerned.
Number one, you have to overcome whether which provision the law, what is the law which bars that application?
Yes, my lord. I'll just,
Number one, huh?
yes, my lord. I'll just look into it myself.
Yes.
Well,
What is your stand?
My lord, it can be taken up as per.
No, what is your stand?
My lord, our stand is they have taken a substantial loan from the bank.
No,
my lord,
that is on
no,
merit.
my lord, the application which was
Merit will
withdrawn-
come later.
My-
What is your stand? How can you file the application when the matter is fixed for final argument?
My lord,
For introduction of new evidence?
my lord, that
Right,
was,
either
we have pleaded-
prima-
we have plead-
either primary or secondary.
my lord, we have pleaded in our, my lord.
So equally it
pleadings.
applies to you, sir.
My lord, absolutely, my lord, you are
When
correct.
I ask the petitioner,
My lord,
under what law it bars? Equally, it will apply to you, sir.
no, there is a
Under
provision,
what
my lord,
law-
under the provision of
Under what
65,
law?
65A, my lord. I
You can file an application when the matter is fixed for introduction or the amendment or to introduce a new documents.
No, it's not a new document, my lord. We had pleaded that. The power of attorney, we have pleaded that power of attorney was executed by
So
defendant number
what was
one.
your application for?
My lord, our application was since in the writ petition, they have categorically stated that the power of
Not
attorney.
the rate petition, sir, before the
My lord,
tribunal.
my lord,
Yes.
when the matter came before this honorable court, my lord, the OA was pending before the learned tribunal. My lord, at that point of time, my lord, he had taken a specific stand
petitioner had taken a specific stand that the power of attorney was given to the original of the power of attorney is in the position of defendant number two. So we had sought for a direction from the tribunal to call for the power of attorney from defendant number one.
No, that's why whatever he's objecting.
When he had come up,
No, that's why I'm saying, sir,
My lord.
whatever he's objecting for allowing the application, I said, what is the, I have pointed a query to him, what is the bar? What is the,
there is no
what is,
bar at all.
what is the law which bars the, what is the
Had
law
I
which
not,
bars
had I not
Number
pleaded-
one. Number
lord,
two,
my lord.
now it is to him. Now it's to you now that under what provisions of law you can file an application for introduction of new evidence or for documents or calling for a record, either primary or secondary evidences when the matter is fixed for final argument. These
Well-
2 points has to be decided. That's all.
Correct.
So since
Last
you can
week,
decide it,
May-
Day after tomorrow, my lord, I'll give lawsuit please.
my lord, last week of May, my lord. Kindly.
not last week. Only.
Yes, any date on last week of
Otherwise, you have to pay. Has it been recovered?
My lord, I have to take instruction, my lord, because it was listed in
Ultimately,
2022.
it's a public money.
My lord, exactly.
It's,
Well,
it's not a public money.
Yes.
It's there.
And 1 crore 45 lakhs, my lord.
Customers' money.
My lord, it is there, my lord. I am not objecting to that. If
What is the status? Has it been recovered? No. I mean, he
recovery
said
proceedings
he
has
has
not
no
been
interest.
Initiated, my lord.
Huh?
Because of the pendency of this writ petition, the recovery proceeding I supposedly have not been filed by the.
There is
bank.
no bar. There is no bar. Is there any bar? Any stay is there?
No, like, the honorable.
Any stay is there for
Honorable
recovery?
High Court
Only observation that will be subject to the outcome of the writ petition.
So-
So I have to take instruction from my bank whether they have
You have to
proceeded
pay.
for the
It's a
recovery
public
or not.
money.
Right, fix
Last chance.
day after
My
tomorrow.
Last chance. Huh?
My lord, kindly consider for
Make
the
it,
last,
make it 2 weeks.
last week,
It's okay.
last week of
Otherwise, a
May.
very short issue.
Yes, short issue.
Uh, on the prayer of Mr.
S. Sancheti, my lord.
S. Sanchiti, learned counsel for the petitioner. And prayer not being objected to by Mr.
R.K. Batra.
R.K. Batra.
My lord.
R.K. or K.K.?
KK is my father, my lord.
Okay,
Left.
R.K. Batra.
He
learned
is left
counsel
for heavenly board. Yeah.
Respond number 1 and 2. List this matter after 2 weeks. Mr. It is made clear that no further adjournment shall be granted on the next date. Huh? It-
I'm obliged.
Highly obliged.
Matter has become infructuous.
No, Your Honor, my senior is on legs in code number 1, Your
So
Honor.
what to do?
Pass it for timely,
What is the matter?
not acquainted with the facts, Your Honor.
Sir, madam, we cannot afford to wait.
Two.
We cannot afford to wait. You see. Otherwise, when do you want?
Any date, short date,
We'll see. We'll see after some time.
pledge.
Item 8. G. Goswami, Naman Conservation, Experiences. Item 8. Yes, who is appearing for item 8? Which photo estate? State level scrutiny committee, welfare of tribes. Deputy Commissioner. Cancellation of caste certificate.
Please, sir. Check this matter, item 8, I meant for item 8, madam. Conducting council A alum is not available today, madam.
Why?
Some personal difficulty.
Method is fixed today, why is it? What is the state level scrutiny committee has considered everything.
I'm not aware of the case, madam.
So what is to be done? We'll dismiss for default.
But last sentence, my lord.
On the prayer of Mr.
My lord, A. Ahmed.
T. Ahmed.
A. Ahmed, madam. On
A.
behalf of
Ahmed,
A.
learned
alum.
counsel, appearing on behalf of Mr.
A. alum.
A. Alam, learned counsel for the petitioner. Submits that Mr. Alam, learned counsel. They are going counsel in this matter. Is in this course today. They for fresh for adjournment of the matter. Mr. Considering that the next matter is of 2016 and pertains and the challenge is to the no. Considering the matter considering the challenge made in this edit petition is to the order dated 21/12/2015 passed by Secretary to the Government of Assam and Chairman State Level Scrutiny Committee within brackets SLSC employed. Whereby the caste certificate, caste/tribe certificate issued to the petitioner has been cancelled and the matter is pending since 2016. Last opportunity is, a last chance is granted. The matter is adjourned on the prayer of learned counsel by the petitioner as a last chance. Accordingly, list the matter after 2 weeks.
Deeply obliged.
At
Huh?
2,
Why we should wait till 2 o'clock?
as soon as it comes.
You are 4 here? Item 9,
Yes.
for respondent.
Yeah, I am respondent.
Yes. What is this, sir?
For the petition.
In this case, what happened?
Honorable M. Sharma. M. Sharma. M. Sharma.
Saiwan.
Huh?
Saiwan.
What is the matter here?
Yesterday, Sagal told me, my lord, he is ready.
He'll be coming. He'll be coming. He's in.
What is the matter here?
He'll be coming. Yeah. I think. Yeah,
Item 9.
yes.
Why not, Mr. Sagala will come in the meantime, I may start
Bank has been directed.
for the respondent, my lord. I am for the financial corporation and they are for the bank. Both are public undertaking, my lord.
So you are
I am for the financial corporation, my lord. Assam State Financial,
Where by the bridge?
Assam Financial Corporation, my lord.
Yes,
But actually, the brief is big, but facts is very short, my lord. I'm sorry, my lord.
he said,
I
he
was
said,
in.
he said, brief is very big, but the issue is very small.
Issue is small, I'm coming. Issue is, my lord, here what happened? Originally a peri-passu agreement was there for both the, my lord, banks also. And we filed a case making the other party as a pro forma. And the judgment was passed for preliminary decree, my lord. And there, my lord, these things are given if your losses comes to paragraph page 19.
Assam Financial Corporation.
Yes, Assam Financial, there, my lord.
Where is the impugn order?
No, I'm coming, my lord. Your losses may just see first. This is the decree, my lord. First, we have filed a suit. They did not file any suit. We filed a suit. In their in our suit, my lord, both parties claim has been decreed. Page 19 for the plaintiff, my lord, it is for 1,82 lakh so and so with future interest. Bottom, page 19.
You file a suit.
Yes, I filed a suit.
Bank file a suit.
Yes,
Petitioner bank.
for recovery of the bank. And there, my lord, we have made Assam Financial Corporation as a party. Now, page 19 of the judgment, my lord, of the trial court. The suit is decreed ex parte, my lord. Last para.
19.
Para 19, page 19. Page 19, last para, my last portion. my lord.
Draw up a decree
Yes.
accordingly.
Preliminary decree. It's a preliminary decree, not a final decree, my lord. Preliminary decree for realization of amount of 1,82 lakh and with future interest of 16.5%. This is in our favor. Now, second part, page 20, my lord, if you also see. This is for proper defendant, Assam Financial Corporation. This is also, my lord, the suit is decreed ex parte and preliminary so and so for rupees 23 lakh and so with 16.5%.
The page 20 is what?
My lord,
This
yes.
is also ex parte,
Yes, my lord, because
preliminary.
he was from proper defendant, my lord, in their favor also, decree has been passed. Now, they have not come up for a lesson of the decree. My lord, because it's a preliminary decree, we have, my lord, they have not approached the court, my lord, for that purpose. Now, we have approached the court, my lord, for final decree for sale, my lord. And that civil court passed an order, my lord, page 29, it will also see. Page 29. Because it is their duty, my lord, to put, approach the court for issuance of the final decree for sale. They have not approached. We have approached the civil court, my lord, for final decree for sale. And this is the final decree, page 29. You also got it, my lord?
Yes.
Now, page 29A, my lord, you will also see. It is further ordered and decreed that money realized by such sale paid in the court so and so for payment of the amount for plaintiff under the aforesaid preliminary decree and under any further order that may pass in the suit and in payment of the amount the court may be adjudged due to the plaintiff such costs, charges, expenses as may be payable under Rule 1 together with subsequent interest as may be payable under Rule 1 together with subsequent interest so and so the court of civil procedure, and that the balance, if any, shall be paid to the defendant or the person entitled to receive the same. This is very clear, my lord, thing that the final decree is that the sale will be conducted and our money will be realized first. Then if balance is there, then that will be given to other, my lord.
This is the decree, final decree passed by the civil court, my lord. In the meantime, my lord, what happened? This, due to the act, my lord, that certified copy is also there, next page. Now, at page 31, my lord. Because debt recovery terminal was there, so we have to approach the debt recovery terminal for this purpose. And debt recovery terminal, my lord, after considering. This is the order passed by Debt Recovery Tribunal 27/2/2003. Your losses may just come to page 33, last para. Need not go to all. Page 33, last para. They are sleeping, my lord. I have gone through the execution petition coupled with a copy of the decree that was filed before the civil court and subsequently issued transferred to tribunal. I have gone through the 11 case records where the order of the learned district judge, Bongaigaon, is available. A certificate has to be issued by this tribunal as because the decretal amount of rupees 1,82 lakhs so and so with cost of rupees so and interest 16.5% till realization. The execution sought by the applicant against the defendant number 1 and 3 reflected the issue certificate accordingly realization of the decretal amount. My lord, this is only in my favor, my lord, because the final decree is in my favor only. They say that if any excess amount is realized, you give it to the others. And now the tribunal has also passed the same order, my lord, on that basis. Can the civil court final decree be modified by the tribunal later on, my lord? That is my question, my lord.
Where it is?
My lord, now they have, yes, that is the my lord question. Now, this page 35, my lord, is the order.
Page 35.
Yes.
This is by appeal.
No, this.
This is appeal by whom? You?
No, they filed appeal.
No, this is
Assam Financial Corporation.
the appeal against this certificate.
Yes, sir. Against that.
The execution sought by the applicant against defendant number 1 and 3 as reflected under column 9 of execution petition. Issue certificate for the realization of decreed amount with interest and cost as per
But this order, my lord, he said, dismissed relief sought by the appellant is dismissed with the above noted observation. The action made given by me, response number 1 is entitled to amount at the ratio of 37 so and so. My lord, he said.
Where it is?
That is at page 42. How my lord, this tribunal can modify the final decree passed by the civil court?
Order, page
Yes.
42.
Yes, 42.
The specific relief sought by the visitor is dismissed with the above noted. What is the relief sought?
Yes, my lord. Relief sought.
Certificate was challenged.
Yes,
Issue of
my lord.
certificate was
Yes,
challenged.
yes.
It
But,
is entitled for the amount at the ratio of 20 basis, the ratio of from
But then he says,
proceeds of the
37.5 basis from the sale proceeds of the
amount of
mortgage
the
property.
Learned's recovery officer so and so is thus modified as per my observation here. So you are agreed by this.
Agreed by these and subsequent orders, my lord.
This is
Now, what happened, my lord, I am submitting that the execution of the decree is, my lord, time limitation is 12 years. Limitation is 12 years. Now, the preliminary decree was passed, my lord, long back. My lord, 24/8/94. They have not done anything. They are sleeping.
So it's only about, it's about the preliminary decree only.
Preliminary decree, then final decree also in 96.
Preliminary decree is
My lord, final decree is also in 1996. If you will also see.
same year.
27 July 96. At page 929.
Then
That was the for
preliminary
sale.
decree,
My lord,
preliminary decree.
preliminary decree is, my lord, I am giving. Preliminary decree is, my lord, 24/8/94.
94.
94.
How you, which, from which year you are counting?
My lord, even in final decree also, my lord.
Ah,
Final decree is of
27 July 1996.
Certificate is issued in respect of
No, first thing, my lord,
final
civil
decree
court,
only,
civil
final
court-
decree only.
No,
Certificate is for final decree only.
no, my first thing,
Both.
civil court has passed a final decree for sale. In the meantime, my lord, DRT has established, that is why, my lord, that DRT has issued a certificate.
Yes.
But otherwise, civil court would have done it.
Hmm.
So civil court's decree, if
Hmm.
it is to be executed, that is the rest is execution process, my lord. The rest is execution process. So it is 12 years. 12 years. They have not done anything. They are sleeping. They are sleeping. And we have,
Otherwise, it should have been as per the CPC.
my lord,
Otherwise, it ought to have been, it would have been as per the CPC and
yes.
if the
Yes.
tribunal was not
Yes,
established.
they would have sold it and I could have bought it, my lord, the entire amount. Since DRT came, my lord, the file was transferred to DRT, so DRT has issued the certificate and accordingly it was sold and I got the amount. I have not got the entire amount, my lord. So how they can get it? The civil court decree is very, final decree is very much says that as subsequent interest as may be payable under rule 1, so and so, and balance if any shall be paid to the defendant.
What, how much you have patched up?
My lord, I got later less amount, man. Less amount. I shall keep that.
So where is the impugn order?
Yes.
This 37.5.
First impugn order is 43. Then all orders are there, my lord. Subsequent orders.
No, finally, what is there?
Finally, my lord, this is that, my lord. For that.
How many appeals are there? How many impugn orders are there?
Lord, there's several impugn orders are there.
2, 3 is the problem.
Yes. Now,
All were rejected there.
my lord, this is the appeal, my lord, by the Deputy Tribunal, page 55, my lord. 47. This is also, my lord, they dismissed the appeal. We filed the appeal. This was dismissed.
How many appeals are there?
Uh,
What is the stage? What are the hierarchy?
yes, thanks. My lord,
First order is of 9/01/2012.
yes.
Then
My lord,
Appellate
9/1/12, my lord.
appellate tribunal.
Yes, 9/1/12 is the, my lord, first order.
This by whom?
This is by the DRT. Then Kolkata, my lord, appellate court, that is 12/12/2013.
That's where.
Then DRT Guwahati, my lord, on 28/8/14, Guwahati directed the
So
petitioner
they
to-
have filed an appeal
Yes,
against the certificate. Right.
no, against the certificate, my lord, they have preferred the appeal.
That's why I'm asking, sir.
Yes,
They have filed an appeal again before the DRT against the certificate.
yes,
Against the certificate.
certificate. But my question is this, my lord, that it is a civil court decree originally.
Hmm.
It is the DRT only.
Sir, let me,
Yes.
please,
Yes.
let me understand the
Yes.
facts first,
My lord.
the stages,
Yes.
sequence of events.
Yes,
So first this is by the appellate the appeal was filed
yes,
against the certificate
yes,
issued before the that recording tribunal.
yes,
Then page 43 is appellate tribunal.
yes, it is appellate. It's the Kolkata.
Then
Then, my lord, again, my lord, DRT Guwahati, they passed an order directing us to pay compensation of rupees 50,000 along with it.
where
That is at page 51, Annexure 7,
this is by whom?
by DRT Kolkata, Guwahati.
Affidavit. What is this? By this page 43, what was the order?
Page 43. I see.
The question of limitation is tried.
Yes. This is the, my lord, Kolkata, they have dismissed our appeal, my lord. That is at page 46.
So this page 42 order is against you.
43. 42 is against me.
42,
42 is against me.
sir, are you ready? For this case? I think you are engaged.
My junior is not here, actually.
You are busy,
Mukesh-
that's why.
Mukesh Sharma was there, I don't know, where is
We'll take it up some other day.
my lord.
So what is to be done?
My lord.
He has not been properly,
Thank you,
Learned Senior Counsel appears to has not been properly instructed, briefed by the junior.
I shall go out, my lord, so let it be fixed in the middle of June, my lord.
Yes, it can be.
Because it will be very difficult, no?
28th.
After 28th, my lord, it may be fixed on 24th of June.
24th of June.
Yes.
But last chance, 2017 matter.
Sure.
Otherwise, we thought of disposing of the matter.
My lord,
We had the
my
time.
lord.
Since he has not been,
Hello.
the Learned Senior Counsel has not been properly briefed.
Actually, ultimate matter is very short, my lord. They were directed to appear before the board. DRT matter, they have not appeared
Heard Mr.
on 24th of June, my lord.
G.N. Sahiwala, Learned Senior Counsel, assisted by M.S.
TJ Sahiwala.
Sahiwala, Learned Counsel for the petitioner, and Mr.
PK Kolita, my lord.
P.K. Kolita, Learned Counsel for the respondent,
Triveni Goswami, T Goswami.
assisted by M.S.T. Goswami, Learned Counsel for the respondent. It would have been ideal time for today, sir,
My lord.
to dispose of the matter.
My lord, today,
as-
my item 6 and 7 are there.
After
This short
submitting
matter.
the letter, matter at some length, come on. As agreed to by Learned Counsel for the parties, let this, no, on the prayer of Learned Counsel for the parties, let this matter be listed.
Well, item
In the
6 and
month
7
of
are there, so
June, huh?
they are small matters.
24 June.
6 and 7.
Huh?
6 and 7. Two matters are there.
24/6. Yes. Yes,
24th.
24.
Huh?
24.
24 June. 24/06/2025.
Item number 9, madam, 24.
Yes. Both single counsel, huh? Yes, sir.
Well, here what happened, my lord? An eviction notice has been issued in respect of land measuring 28 bigha Kolkata 2, sir. My lord. My lord, in fact, my lord, this land was under the possession of the garden since long back, my lord. And tea was grown there, my lord. But it seems that it was a government land, my lord. So we approached this honorable court saying that we are giving alternative land for that because this is inside the garden. The compactness of the garden will be destroyed if the land is given to somebody else. On the border, we shall give the land which will suffice. That was the interim order was passed on that basis, and government also said that yes, we shall see whether that can be. Now, what land was offered to them, my lord, at that point of time? Subsequently, they filed an affidavit that land is, my lord, some other persons are there and they have constructed their houses. So this land cannot be taken, my lord.
Alternative land.
Alternative land. Then, my lord, as allowed by the court, we submitted a subsequent affidavit, my lord. That's a vacant land, my lord. That is, we have filed on 5/12/22, my lord. That is the, my lord, affidavit. Here we have said that this vacant land we are giving, we can give it.
Where it is?
Page 30, my lord, regular page. Para 6.
30.
30. Para 6, page 33, my lord, your lordship. That with regard to statements made in paragraph 6 of the affidavit conversion, 7 except question.
Page,
Page 33.
which item?
Hello? Item number 6, well, WPC 388.
393.
Oh, it is 393. Well, your losses may take up 7 then. Huh? Oh. Full chat.
Why two repetitions?
No, these are two separate, my lord.
Huh?
These are two separate. Your
No.
losses may take up 388, my lord, first. 388 is very short.
No, that's what I'm saying.
388.
393 is what?
No, 388. I'm coming to that, my lord, later. Your losses may take up 388. I thought, my lord. And there, my lord, your lords will find the my affidavit, which is at page 30.
13.
No, 30. I think it is 30. Affidavit filed on 5/12/22.
Affidavit in reply.
Affidavit.
Reply.
Yes.
Ha. Para?
Para 6, my lord.
Hmm.
You have clearly said, my lord,
Yes.
that with regard to statements, affirmations made in paragraph 6 of 7 except which are matter of record, so then the answering the opponent herein state that if the lands from the midst of the garden, which is already tree plantation, is being taken away, same shall completely disturb the production of the garden, such the petitioner herein like to submit that petitioner is ready to give away land located in Dag number 29 part and 44 part measuring 28 biga 4 quarter 4 liter in exchange of the land already in possession of the petitioners. The answering opponent further states that the land is located at the boundary of the tea estate and the vacant land. Originally, my lord, they have said that that was not a vacant land because originally what we have given, now it's a vacant land. Now this land can be taken away by the government. We have given the photographs also, my lord.
Drawing number 29 part and 44 part measuring 28 biggest 4 cutters and 4 vessels be taken from the intent. But how can you,
my lord?
What is your, basis of saying that they should take it?
No, my lord, it is
I understand, but then on what basis you are
Well,
saying that they
well,
should take it?
entire garden will be destroyed, my lord, because it is the middle of the garden. They are in possession of the land since a long time.
Yes,
And
if they agree, it's okay. Otherwise,
No.
what is this?
Originally-
What is your right
No,
to
earlier-
claim that they
yes.
should be, they
My
should
lord,
take this and
in the
protect
court-
your
the
the
court,
land which you have already occupied?
No, my lord, first thing, my lord, we have said, my lord, that
So that is your only case.
no, they have agreed.
That
my
you
lord.
have already, tea garden is
Yes.
already in operation where you have acquired a land,
But-
where you're using a land
Yes.
which admittedly belongs to it's a government land.
Government.
Now you are offering an alternative law. You have
Well,
offered an
on the
alternative.
boundary,
And they say
so
in the,
that
in the
the-
boundary,
Okay.
they said initially, no, it has been occupied by
Some other-
some other persons by constructing
Yes.
building and all.
Yes.
Now you are offering this
Vacant land.
offered,
Vacant
yes,
land.
That instruction I had not had because lordship, in our initial affidavit, we have said categorically
yes.
that those lands are already allotted.
No,
to
that's
land
why
scheme.
they're filing the affidavit, they are showing that.
That
reply.
of course, I do not have that affidavit. I have to take instruction or alternately,
Ah.
your lordship may direct them to approach the deputy commissioner.
You may approach it.
He may
by filing
approach,
this.
no, he doesn't have any indefeasible right over this.
So you approach the deputy commissioner by giving this, by offering this alternative plot.
My lord.
Because you will not pass, you cannot issue a mandamar
No, my lord.
that your offer should be accepted
No, my
or
lord.
and all.
No, my lord, they have agreed, my lord. It is not that, my lord.
No, it's okay. We'll approach it.
Government also want, my lord, because the tea garden, my lord,
I understand.
Yes.
That's why maybe there's a feasibility of accepting, the possibility of accepting your proposal.
My lord.
No, going into, we pass and we cannot decide, sure, mandamus to consider.
Well, let them take the instruction, my lord. That will be better, my
No,
lord.
it's better you approach.
My lord?
We'll close this. If they, if you agree, you can come back again.
Yes.
Because it has to be decided by the deputy commissioner or by
correct, my lord.
The
Only
commissioner
thing, my
will
lord,
make approval
We'll
for
record
that.
this, in view of the statement made on oath by the petitioner by offering this land,
Yes.
which the government initially has
Yes.
By recording that, will direct you to approach the deputy commissioner.
Deputy Commissioner, and then he will take
And
approval,
consider-
with approval from the government, he will give.
No, they will consider. Will provide you to, will direct you to approach the deputy commissioner within 15 days.
Yes.
All right. Thereafter, deputy commissioner to consider
Yes.
within.
It
Consider
is a
which-
vacant land, because you have said the vacant land.
Yes, heard, Mr. What about this other one?
Other one I shall submit later on.
What is this?
That is different, my lord. That is.
Why this has been listed together then?
No, together, my lord, because this same company, that is why.
Lot of
Otherwise,
Same company, this cannot be listed
No.
together.
my lord.
Anyway, we'll finish it up this.
Yes.
Heard, Mr. G. N. Sahewala, London Council for the London Senior Council assisted by MS DJ Sahewala. She's your
Daughter-in-law.
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 Okay. Daughter or daughter-in-law?
Daughter-in-law.
Daughter-in-law, okay. And Mr. BJ Talukdar, London Additional Senior Government Advocate.
Assisted by Minister.
Existed by
Yes.
PKMAD. And PR Mahanta. Really, you're right. Huh? By you're basically challenge the eviction
Eviction.
where it is.
My lord, that is, my lord. Annexure 1, my lord.
Page 16.
Yes, basically.
Next para. By filing this writ petition, the petitioners or petitioner? Petitioner has put to challenge the letter dated 21/12/2015 issued by the circle officer, Morigaon Revenue Circle, whereby
The initial order was also passed on that basis, my lord, 27/1/14. Because we have.
whereby a notice has been issued to vacate the plot of land measuring
28 bigha, 4
Ah.
katha 2 lita.
will, this is the same measurement, 7B.
Total land is, my lord, 28 bigha, 4 katha 2 lita.
28, total, 28 bigha, 4 kata, 2 lectures. At Moja Uttar Kala of number 2, Nelly Government Dag number 197, 218, 220, 197, page 16, This stuff. The next paragraph.
We are growing tea bushes since 1963, my lord.
That's okay. The case projected, no, the case of the petitioner, in short, and in brief, is that the petitioner is growing, what is tea state?
Tea bushes there, my lord.
Huh?
Tea bushes in
Tea
this place.
bushes. Since 1963,
Yes.
over a total area of 425 hectares, which is covered by which is now covered by the tea plants.
Yes.
No, what is that?
Which includes this land, my lord.
Is that the petitioner? By way of tea plantation, including the area of 78
My lord.
78 bigha,
28 bigha.
28.
28.
78 or 28?
28. 28 বিঘা 4 কাঠা 2 লিটার।
Okay, 28 bigger, 4 kathas, 2 lectures. Which is admittedly a government land, government land. Listen. Next para. The
Initially, we offered my lord land.
the petitioner initially offered an alternative land equal to the land covered, the occupied for tea cultivation to the in lieu of the land the petitioner occupied for cultivation in the border area, a boundary area of the tea garden, tea estate, which initially, which was found to be occupied by the some other occupied by
As
some
per
other,
government affidavit. my lord.
by some other persons. Mr. The petitioner having having found that the alternative plot, where it is, what is that earlier or initial alternative plot?
Yes, in the petition itself.
Just tell the name.
My lord.
Alternative plot measuring.
And-
This is the area,
Yes, sir.
settle is there.
My lord, yes.
Where is that?
My lord, at paragraph 17, my lord, it is there. Mm. Oh, I'm sorry. my lord. I'm sorry. I'm giving out.
Sir, where is that?
In our affidavit paragraph 6.
Where it is? Page.
In page 3 of our affidavit. Affidavit filed by the district commissioner.
District Development Commissioner.
Yes, madam. The paragraph 6, page 3. Lordship will find that the garden authority encroached so and so, so and so. It is admitted that after receipt of the notice to vacate the encroached land, the general manager of the tea garden submitted prayer, plus circle officer Murigaon circle with a copy to the deputy commissioner to exchange the encroached government land with land of Dag number 208 and 2010.
Yes,
Yes.
yes. Initially offered.
That was initially offered.
Initially offered, huh? And having admittedly occupied the aforesaid area of the government land for tea plantation, which is within the center of the
Yes, garden.
tea garden. A tea estate has offered the land of offer the government for exchange the land of Dag number 208 in 1210
10.
of redeem grant -1 belonging to the garden system. On such offer, the circle officer Morigaon had verified the tea estate and found that the said land offered by the petitioner are being occupied by some local people by constructing dwelling houses for which the proposal could not be materialized. Mr. Next para. Having confronted the such situation, the petitioner has offered the alternative land located at Doug number 29, within bracket part, bracket close, and 44 within bracket part, bracket close, measuring 28 bigas, 4 katas, and 4 leches in exchange of the said land already in possession of the petitioner. Next para. Mr.
It may be written, my lord, that this land is a vacant land.
No, we'll say, we'll record it. Mr. G.N. Sahewala, senior counsel, referring to the affidavit filed on behalf of the petition, affidavit filed by the petitioner, submits that the land offered above, the alternative land offered to the government is located at the boundary of the tea estate and is a vacant land. Listen. The land is fit for cultivation and there is no dwelling house therefore the land located at Doug number 29 part and 44 part measuring so and so can be and may be directed to be taken from the petitioner in exchange of the land measuring 28 so and so 28 bigger 4 katas 2 leches of Moja Uttarkala of village Nelis and that which we have read in the notice, page 16. Falling under so and so. Mr. Next para. Vijay Talukdar, learned an essential government in the book. Fairly submits that. No, submits that. Since the initial offer, the initial land offered by the petitioner is being occupied by the petitioner and not fit to be exchanged. If the petitioner has alternative land which the petitioner seeks to offer, the petitioner may approach the concerned authority, placing his grievance so that appropriate consideration may be made. Next page. Having considered the submissions of learned counsel for the petitioner, learned counsel for the parties, and also in the facts and circumstances of the case, particular to the effect that the land from which the petitioner is sought to be evicted or directed to be vacated is a government land which falls inside the estate of the petitioner, and the petitioner having offered an alternative plot which the government, for which the respondent authorities are not to consider, I deem it appropriate. I am of the considered view that no further determination is required to be made to the legality and otherwise of the impugn order dated, impugn order, impugn communication, impugn letter dated 21/12/2015, passed by the circle officer, Morigaon Revenue Circle, directing the petitioner to vacate the land at Moja Utkara, so and so, so and so. Huh? It would be appropriate to direct the petitioner to approach the deputy commissioner or district commissioner, district commissioner. Now it is district commissioner. District Commissioner Morigaon. Morigaon district to no, what do I say? Placing his grievance for the exchange of the land which he is in occupation. Mr. Accordingly, it is directed. Accordingly, the writ petition is disposed with the direction of the petitioner to approach the district commissioner Morigaon by placing his grievances as regard the alternative plot in exchange of the land measuring 28 so and so, bigger so and so, so and so, and so and so, which the petitioner has. No, I don't think.
There are 6 one.
Has offered a land located at dark number 29/44, huh? So and so, so and so. Within a period of 15 days from today, and it is that on such approach, the district commissioner shall consider the case of the petitioner and first appropriate orders. Consider the case of the petition within a period of 2 months thereafter. With this instance, right, this court.
Much.
7 will.
At 2, my lord.
That is item 7, right?
At 2.
That is, this one is item 7.
Yes.
388.
7.
6
will
will take it up.
At 2, my lord.
Then you don't check it. What of the item 10? Anybody appearing for item 10?
I am appearing for the petitioner.
What is there?
On the other side is there.
What is the matter?
The matter is it's an appeal from the order passed by the revenue court, revenue board.
So
Whereby
what-
my order of granting ownership by the ADC was cancelled.
what's the wrong? What's wrong?
The rank is the perversity, because while
Perversity is a big word. It has
but while
huge connotation. We'll see, anyway. Yes, sir.
No, this is the case, my lord, where my Pata land has been, my lord, recorded as government land without any reason, my lord. Your lawsuit, see, my lord. This 93 bigha and odd land has been declared as my lord government land. We are saying that this should be deleted. My lord, if your lawsuit will see Annexure 3, my lord. Annexure 2, page 18A.
Hmm,
18A, my lord. Para 1.
hmm.
The settlement officer Nagaon High Order declared an area of 93 bigha 2 katha etc. land as Sorkari from Kutari Gaon. This road also. Well, I do not know, my lord, how it can be private land can be declared as a government land. Either they have to acquire it. Details of the declared land so and so and so. The total area held by the garden, next page, NLR grant to the.
What is NRL grant?
New lease, you know, NLR to new lease grant. Huh? New lease.
New lease what? NRL.
Is segment or something, my lord. Total area of land per person 179 bigha, only 86 bigha land. That number is left with the garden. The land has been declared Sarkari by the settlement officer Nagaon, is still in the possession of the garden under cultivation. Land ceiling case number so and so so and so. Propulsion register has been examined. It has been seen that from the return so and so. Authorities land exempted under certain photo of the ancillary cultivation has been kept by the garden. It also found that the total area of the tea cultivation land under so and so, given time is 2249 bigha, 4 katha, 8 licha, and the land admissible under Phare has already been given to the garden. It is therefore certain that land measuring 93 bigha 2 katha 8 licha is purely Sarkari and tea garden is encroaching the Sarkari land. But the said land is under possession of tea estate management of garden authority has been paying the allotment settlement of the said land. The garden authorities have been paying TB revenue regularly. On the other hand, rejection of the tea garden from the possession of uprooting plants will not serve any purpose of the land question the tea plantation all sides. Under circumstances, prior to tea garden for settlement of so and so, Sarkari land is provided here with so and so. Now, my lord, you will also see next, my lord, the letter of the Deputy Secretary, page 21, my lord. With reference to above, I am directed to say that it seems to be a case of restoration of 93 bigha. My lord, we are wondering, but that is the question. 93 bigha 2 katha so and so land, which Gopal Krishna Tea Estate has purchased in 1963 and been in continuous possession under actual tea. The circumstances under which the idea was made Sarkari are not clear and not adequately explained in your report. However, the garden authorities may kindly be directed to produce the purchase documents, if any, in respect of land in question, and then you may resubmit the same to the government. Other inquiry response. Now, my lord, next page, my lord. Additional Deputy Commissioner, my lord, had given. On the above subject noted, above, I am to say that the copy of the Chitha enclosed the total area of 93 bigha 2 katha soil and land of Gopal or made Sarkari by the then settlement officer by the order number so and so, but no reason for so doing appeared to have been recorded as per the copy of the Chitha. Well, can a land of the garden, pata land of the petitioner can be made Sarkari without any authority? The tea state authority have paid before the government restoration of the land made Sarkari to lease, and government has now wanted to know the reason for making the land Sarkari. Since the reason for this was not mentioned in the Chitha, we are not in a position to apply the government about it unless a copy of the so and so available to us.
What is this? This is not legible also. Unless copy of what?
Copy of that SO's order, settlement of such order, number so and so is made available to us. Well, without nothing, my lord, and settlement officer can made a patta land with Sarkari land, my lord. First thing, my lord, it is to be acquired.
To furnish, what is this? What is this?
I therefore request you kindly to furnish the copy, certified copy of the said order so as to enable us to report to the government. Now, next page, my lord, page 23, he says, With reference to your letter mentioned above, I have not to inform you that the settlement order numbers by the settlement officer Nogam, this is not traceable in the record. This is for your information. Sir. Then, my lord, we filed a detailed request to the additional chief secretary. My lord,
What is NLL grant?
Land Revenue Society.
Now what happened?
No, my lord, they have issued a letter, my lord, for demarcation of this land. My lord, that is at page 28. The circle officer. Regarding 103 bigha. Out of 103 bigha, my lord, 93 bigha is my own land that has been made Sarkari without any authority. 10 bigha is land is there, my lord. That is another aspect of it.
Huh?
The 10 bigha 187 dark, that is, my lord, different.
187, dark number.
187, 10 bigha dark is there, my lord. That is a PS, my lord, it's a government land.
It's a government land.
Government land. Except that, my lord, that is wrongly made Sarkari, my lord. So 10 bigha, this I can offer, my lord, this is also inside the garden land. So 10 bigha we are offering, my lord, separately.
Out of 87.
Out of 103.
Dark number 87.
187.
Which we have disposed of.
My lord, no, in exchange, this, my lord, we are offering separately.
I
Because
would
it
like
is
to
in
inform
British
that the
contract.
following schedule of government land under Kuthari Bagisa Isam will be demarcated on 18/4. As the below mentioned schedule of government land is adjacent to T state, then so you are requested to.
So this is the land, my lord, which is
Which
actually, my
land
lord,
you are saying now?
yes, 93 bigha is, my lord, there is nothing.
No, this demarcation is what?
My lord?
This page 28 is of what? Which land?
No, my lord, this 93 bigha plus 10 bigha. 93 bigha my land, which is, my lord, wrongly made Sarkari. And this dark number
Where is
187, my lord.
93? Yeah, where is 93 here? Dark number?
Well, no, if your losses deduct 10 bigha from 103 bigha, then it comes 93 bigha.
Huh?
93 bigha. 10 bigha, my lord, 187 dark is 10 bigha. That if your losses deduct from 103 bigha total land, it comes to 93 bigha. The other darks, my total land, my lord.
No,
Wrongly,
this-
my lord, the circle
no,
officer
no,
made this land
this-
for carry.
103 bigha
Yes.
and 10 bigha is what?
10 bigha, my lord, it appears, my lord, it is government land.
So our total is 103,
Yes.
10 is government.
10 is government, 93 is my land, which is wrongly made Sarkari by the settlement officer.
It's in 1970.
My lord, 70, we are paying the revenue, my lord. We came to know, then later on we have applied for it. Whenever we know, my lord, in 1990 we have applied for it. 19, not 1990, yes, prior to that, my lord. 76.
Yes.
78. 78 we have applied for it.
What do you say?
Lordship, in our affidavit, Lordship, may kindly go through the paragraph 5. Affidavit filed by the respondent about 4.
There are 5.
Paragraph 5, Lordship. May I read, Lordship? That's with regard to the statement made in paragraph number 8 of the writ petition. The defendant states that as per the report of the report from the circle officer, Mayang Revenue Circle, a letter was issued to the authority of the Gopal Krishna T State, white letter number so and so dated on 15/12/2015, informing that the following schedule of Govland under Kuthari Bagisa Kisam would be demarcated on 18/12/2015 and also encroachment to be cleared on 23/12/2015. As per the up-to-date report, up-to-date land records, this area are the government land and the government and the land areas under dark number so and so, so and so.
Yes.
Yes, this is the, my lord, that table. which are, my lord, the land is, my lord,
They are challenging that,
lordship,
except for 10 bigas,
lordship.
93 bigas belongs to him. How can this be made a Sarkari land?
My lord,
And there is a
after
correspondence.
demarcation, my lord, it is there.
There is a correspondence by the authorities that there is no reason, there is nothing to show that how this has been made Sarkari land by our own
My lord,
correspondence.
whether it is made as Sarkari, my lord, on when, my lord, it is not.
No, it is by you only, your
Lordship.
authority is saying that on what basis this has been made Sarkari. Page 127, 24 of the writ petition. Anyway,
24.
huh?
My lord, this is, my lord, that representation, my lord, is submitted by the petition on page 24 in the writ petition. Lord. So, my lord, that, after the, my lord, the demarcation of the said land, my lord, these are the government, my lord, that government land.
Where
These
it
numbers
is?
are given.
Page 8. Para 8.
Para 5. Lord.
What demarcation? No, it is not demarcation.
No, my lord, lordship,
One is, the following measurable government land understood so would be demarcated.
lordship.
This is what they are saying. This 93 out of 103
Lordship.
because 93 belongs to him.
My lord, this
How this
dark
can be
number,
made?
these dark numbers, lordship, my Kalisida.
Except for 187.
No, lordship, my lord, this dark number, they are encroaching the government land.
That's what I'm saying.
Lordship.
They admittedly, by your correspondence, it says, though it has been made government land, Sarkari land, Sarkari, there's no reason, there's no documents why this has been made. They are claiming that since 1963, it belongs to
Then,
them.
my lord, I have to, my lord, produce the record, my lord, whether, my lord, that how, my lord, this has been, my lord, the government land.
Therefore, the government has asked the deputy commissioner or the circle officer to furnish the certified copy and all other documents.
That is, my lord, everything will be available in the records, lord.
It is not a record. What about those statements?
Page 23 says it is not received. That may also.
From where you will get the records?
Bear it.
So what happened after the demarcation?
Lordship,
Any
my lord,
demarcation is made or what?
lordship.
Any demarcation has been made.
My lord, it is done, my lord, that paragraph 6, lordship. Paragraph 8,
Report from Sarinagar proposal received from Patruli Gopal Krishna Tea State by so and so wherein the tea garden will offer alternative tea land in place of government as the enclosed government land in the midst of the garden, most of which is under tea planting. But on examination which is found that the area under Dag number 150, a special periodic patta of Puchari which is proposed for extending government land is neither suitable for cultivable purpose nor fit for residential purpose.
the circle officer Mayang also issued a letter to the authority of the Gopal Tea State, by letter number so and so dated on 24/12/2015. They submit the relevant documents in favor of their claim that 93 bigas, 2 kata, 8 lesas of the Puthari Bagisa Kisam was declared as Sarkari unilaterally by the settlement officer Nagaon in 1970, but the authority Gopal Tea State have to fail to submit the documents suitable or sustainable their claim. In 1970, my lord, it is the Sarkari land. My lord, they are asked to submit some relevant document that was not, my lord, produced before the concerned authority. Next paragraph, lordship, that with regard to the statement made in paragraph number 10 with the of the writ petitions, the deponent beg to state that as per the latest land policy, 14 bigas of government vacant land under the Dag number 158 of Puthari Bagisa Kisamot was distributed among 56 landless tea gardens workers on 24 January 2016 under the above program dated 24/1/2016. Each tea garden landless family has received 1 kata 5 lesa of government land and allotted certificate to 56 landless tea garden workers who are received accordingly. Well, this land, Malad, is a government land, Malad, it was distributed to the landless person of that laborer of it.
Not all. Only one Dag. One Dag number 158.
158.
That's all. Rest there are 70 bigas. 7.
The next paragraph, Lordship. With regard to the statement made in paragraph number 11 and 12 of the petition, the Department back to state that 14 bigas of government land covered Dag number 158 Kuthari Kisam, Kuthari Bagisa Kisam, which was distributed 56 landless tea garden, workers 24 January 2006, the total vacant land. The government mentioned below the enforcement, the encroached by the authority of the Gopal Tea Estate is presently doing tea cultivation. But this is the 70 bigas of land they are encroaching, Lordship. Dag number 190, 187, 186, 168, 161, 264. Total 70 bigas of land, Lord. These are the government land, my lord. They are encroaching. That's why, my lord, this notice has been issued to, my lord, that the concerned tea estate.
We are not coming to the main point.
My lord, they have been asked several times, my lord, to produce fact for anything.
You are not coming to the main point.
Lordship.
No one is disputing that. He is also saying that this has been made Sarkari, right?
Lordship.
How can you make it Sarkari? Because it's a private land. And there's a documents, correspondences, where it shows that how this was made. There's nothing.
Oh, that is not, my lord, mentioned in my affidavit, Lord.
It is not. That's why.
How, my lord,
It's-
this has been, my lord, made Sarkari, Lordship.
No, that you have been. This has been annexed. You are supposed to respond to that.
That's why, my lord, Lordship, I submitted my.
And it says that the record is not traceable. Where is page 24?
23, my lord. 23.
Is not traceable in our records. This is
No, my lord,
for
this
you.
is the settlement order of so-and-so 1970.
The
Huh?
settlement order officer, my lord.
No, that's what I'm saying. Even if you produce the record, if the record is not traceable, how can you, from where you will produce?
Let me try it, Lordship, my lord, whether if it is
Question of
not
right,
available,
if you are
Lordship can
saying-
go as per the record available in the, my lord, petition. Let me, my lord, that take instruction regarding that, my lord, the police.
My lord, so far 10 bighas is concerned, I am offering separate land, my lord. In my affidavit, I have said I am offering separate land. So far 10 bighas is concerned, because that is a government land, so I am not disputing this, my lord. So far 93 bighas is concerned, it's my land, wrongly, my lord, made.
No, sir, you are also not able to produce any document.
No,
So
my,
that it's your land.
no, my salary is there, my lord. My salary is there.
Both are-
That is the record shows, my lord, yes. It's a lot.
Both are sailing on the same boat.
My lord, at page, my lord,
They
if
are-
your lord-
the
no,
government is
if your
also-
lordship, if your lordship see, my lord, that,
You said you have purchased the land.
yes, my lord, your lordship may
Is
see,
there any documents?
my,
show?
my affidavit dated 16/6/23. This is the Ramavandi copy, my lord.
Affidavit?
Dated 16/6/23.
Reply.
Yes, affidavit, no, additional affidavit.
One
Additional
is a-
affidavit 16/6/23.
16/6.
23.
There is no affidavit, additional affidavit.
16/6/23, my lord. Extra.
It's only reply affidavit.
No.
Reply is there, my lord, there is no annexure.
No,
In my affidavit, my lord, reply affidavit.
No, he said
My
additional.
lord, this is the, my lord, affidavit, my lord. I don't
It's
know
not there.
whether it's there.
It's affidavit in reply only.
No,
We're not talking of
additional
reply.
affidavit, my lord, just, this is the affidavit.
আছে নেকি? নাই, নাই।
Yes, sir.
অকল reply খন আছে।
It's not there.
Yes, it, my lord.
Moja, Goa.
Page 5, my lord, it says, my lord, page 5. This land belongs to Gopal Krishna Tea Estate. This last order may be seen as per the order bearing number so and so, passed by the so and so in Chitha number so and so, new lease grant, except the plot of land measuring 86 by rest of the land falling under DAG number so and so, has been converted to government land. Well, this is the, my lord, this is my chita, it is my name, my lord. The land is my name. How the settlement officers, my lord, chita, my lord, passed an order and converted it to government land.
When did you come to know, when did it comes to your knowledge?
My lord, yes, after coming to know immediately, we have filed a application, my lord, in 670. My lord, yes,
This is converted in
78, my lord. We have filed the application in 78. This was in 1970. In 78, we have filed the application, my lord, saying that some lands have been made sarkari by mistake in your office. That is my first application. Immediately upon coming to know.
In the vernacular, my lord, it is not stated, it is converted to the, my lord, that government land. It is a government land. In the vernacular, it is clearly stated. Next question, মাটি সরকারি হয়। But that is, my lord, nothing has been very converted. It is already the government land, lordship. DAG number 168, 161, 158.
সরকার করা হয়, সরকার হয়।
সরকার হয়,
Because
মানে
this
সরকার
is-
করা
this
হয়
is the-
and
this is
হয়,
the-
this is two different lordship.
My lord, this Jamabandi is in my name. This in my name, the entire land is. Now this has been made sarkari.
No, it's Sarkar hoy. That
Sarkar hoy means-
government,
How?
is not
It is a government land, but it's not converted.
Oh, Jamabandi is in my name. I do not understand how this order is passed. That is why
order
order,
bearing 34. Is it correct?
my lord,
Lordship,
As per the order bearing number 34, that is 060165 passed by ASA, a new lease grant has been, that is NLR. NL.
Yes,
Grant has been granted in favor of Gopal Krishnan in respect of land
the
falling.
falling under 12102.
By
36.
yes.
Yes, this is correct, my lord. First paragraph is correct, my lord.
Second paragraph, lordship, that is
What do I, how, what,
Chita
is the-
number
what-
one.
what's the system of granting new lease? New lease rent? What's the new
my lord,
lease grant?
his, my lord, that his, my lord, only 86 bigger of land, my lord, in his, my lord, that tea company or tea estate.
Where does it say?
Lordship, may kindly see the next paragraph. As per the order dated so and so, to pass by the
ASO, a new
yes,
lease grant.
the
has been
CETA
granted in
number
favor of-
721 of 102 and oblique 36 new lease granted except the plot of land measuring 86 bigger. And the rest of the land are falling under, my lord, the government land.
Where it is said?
Lordship, my lord, kindly see the second paragraph.
You
My lord,
say
that-
this is not correct. New lease grant except the plot of land measuring 86 bigger. The rest of the land converted bigger. It's why, it's, what does it say? Is it correct? First three lines.
Lordship, it is correct, lordship, that up to 86 bigger, my lord, is land in the name of the, my lord, that Gopal Tea Estate. And
Is it-
the other, my lord,
No,
other
as
lands,
per the vernacular, is it correct?
lordship, in vernacular.
You are disputing the translation. second
Lordship,
para.
lordship, my lord, there is, my lord, in the, my lord, the vernacular, it is nowhere mentioned,
Yes, my
it is converted.
It's correct, my lord. Thereafter, bade, that means otherwise, baki, after, others, my lord, that means that 168, these are Sarkari land. This is government land.
Is
my
the,
lord.
the DAG numbers have been mentioned in the, my lord, that vernacular, lordship, 168, 161, 158, 190, 186, and 264 DAG. These are, my lord, that 93 bighas of land, my lord, these are, my lord, that government land. Only 86 bigha is the name in the name of the, my lord, Gopal Tea Estate.
That is not properly written, my lord. That is not correct because the other orders are very much there.
My lord, in the vernacular, it is nowhere mentioned, it is converted to.
Let them produce the order 6309. why this order has been passed.
You give that, it's not brought on record.
My lord,
It's not brought on record.
No, my lord, we have not received, my lord, whether with the order to one, file করা তো।
They're different plots. sir.
my lord,
That is, we have disposed of the other one.
Yes.
Check it there.
that is different number. my lord. That is different number.
7 to 1.
Number 7 in text.
Sir, he is disputing the correctness of the translation.
My lord, this is not the correct, my lord. That order of the settlement officer, that is only recorded by the lower authority. That is the main order is there, my lord, that settlement officer has converted it into a, my lord, that is the, if you also see, my lord, that ADC order is page 22 and 23, my lord. Absolutely clear. Page 23, 23. Page 22 and 23. Page 22.
Lordship, asking about the NRL grant, new list.
That we have came across from,
Lot.
we have came to know from here on.
That is page
What-
22.
What is R? New lease we can understand, new lease grant.
New lease rule.
What is R?
I think. New lease rule.
NLR. No, NLR grant. What is R? Stands for?
That page 22, my lord. That is absolutely clear. What my lord says.
What is letter? Where is the letter dated 02 December 2015?
My lord,
Where is the letter dated 02/12/2015?
12/2/2015.
Hmm.
That is
Submitted by you. Letter dated 02/12/2015.
submitted the letter, my lord. On 19/12/15, 29/12/15.
Just dispose of.
New list rule grant,
New lease rule. That is
NRL.
What is the letter submitted by you? 02 December 2015.
02/15, my lord. It is, we submitted 19/12, my lord. not-
Read the order of 16/05/2023.
এইটো কেছত দিছিলে নি?
What can be done?
What is my lord? Lordship, kindly allow me my lord, to produce the record regarding my lord that my lord that original record of Sita and other things. Lordship. My lord, whether it is converted or not, my lord, is a government land, my lord, will be clearly stated in the Malad sheet also. What Malad that, how much land Malad they have in their, the name of the Malad that concern Malad Gopal Krishna Tea Estate.
You don't have documents of,
Malad, they neither, they have nothing to Malad that annex anything Malad regarding Malad that.
No, this Chitha is
Chitha-
annex, Malad. Chitha in my name. Chitha is in my name.
problem is this additional affidavit is not in the record.
No, not in the record.
I shall find out, Malad. Otherwise, I have to file it separate. We filed it on long back, Malad, 16/6/23.
Okay, orders are also in there. Oh, you will go, sir. You do कैसा file को send?
Well, I do. 16/6, we shall, Malad, your office may direct to office to find out it, Malad.
And also you produce the records.
Lordship,
or
Lordship.
relevant records. Next
Lordship.
week.
Next week.
Next week, Malad, is because Malad, counting is going on 11, 12, Malad, they will be busy,
Why
Malad.
we are concerned
Malad, now, Malad, it is, I have to bring it from the Huzai district. Malad, earlier it was the Nagaon district. Now.
Morigaon, Morigaon.
Huh?
It is Morigaon.
Morigaon, no?
Morigaon.
Morigaon is just nearby.
Lordship. Malad, that's why they are busy, will be busy in the counting, Lordship. Lordship, can it be fixed on?
Can we install the court proceedings because of the panchayat?
No, Malad.
Can we install the court proceedings because of the
No, no,
panchayat?
no, no.
Except for polling. We are having a holiday tomorrow and not
7.
for
Lordship,
polling. And counting also, we need to have a close the court.
Lordship, can you fix it on 15, Lordship? On 15.
After the result again, these officers will be on something on hangover.
Number 15, Lordship.
15.
15.
Yes.
15 May.
Mr. J.N. Sahiwala, London Senior Counsel, assisted by MS TJ. T for Telangana. TJ. Sahiwala for petitioner. And Mr. J. Hendik, Leonard, State Council for respondents. Next.
Respond number 2.
Are they, during the course of hearing, and yeah, for respond,
I am 4, 5, and 6.
Hey, you said yes, but also.
4, 5, 6.
If you are not clear, let me know.
Very
It's very difficult
But I
to correct every line. Huh? Got it? No, first the correction, first 150 you write. Huh? You have already written. See, what you have
I know.
written?
It offset of the expense.
Which ones? MS PR Mohanto, State Council.
Sending council revenue and
Yeah, for respondent number 1. 1, 2, and 3, and Mr.
4, 5, 6. 4, 5, and 6.
4, 5, 1. You serially you maintain that whoever is there. Chronologically. Right. During the course of hearing, it is submitted by Mr. Sayola and Senior Counsel that he has filed an additional affidavit on
16/6, no, 5/12, 16/6/23.
16/6/2023 by bringing on record the copy of the, what is this?
Affidavit, additional affidavit.
No. What is this?
Oh, Jamabandi.
Jamabandi.
Yes.
Jamabandi.
Yes, my lord.
We call it Jamabandi or what?
Yes, my lord, Jamabandi.
However, same is not available on the record, in the record. Register to verify. And if it is filed to place on record. Considering the claims and counterclaims. Claim and counterclaim of the parties with regard to the conversion of the
Yes.
land measuring 93 bighas, 2 cutters is latest as Sarkari land by order under NRL grant number 102 of public 36 by order number 6309 of 1970. The Mr. J. Henry Glenn Medicine, State Council to produce the reports on the investment. As agreed to by the Land Council to the parties. Let this method be listed on 15 or after 15.
What's it?
15/05/2025. For further consideration. No, for further hearing.
My lord.
This writ petition is filed challenging the order passed by the Board of Revenue. This writ petition is filed challenging the order passed by the Board of Revenue by which the ownership right granted in favor of the petitioner was cancelled. On a ground that I was not in possession at that relevant point of time and relied on a report submitted by the circle officer. But that circle officer report, subsequently there is another report of 12/8/2015, which has
For
not.
the respondents.
Senior counsel, Mr. J. Roy, appears.
So what is to be done?
His presence is necessary, Lordship. Because of my lord, he's challenging the order of my lord that.
That has been given to the private respondent. Huh?
No, my lord. My father was the Khatiyandar.
No. By cancellation, the land has been given to the private respondent.
No, it has not been given.
It's with whom?
They claim to be the owner of the land, and from their predecessor, my
What is
father.
the impure order? Let us see.
Impugn order, your lordship will find at page 60.
60.
If I may read.
60. Long order.
Yes, madam.
Appeal. This is an appeal case under section 70 of Assam Temporary Settlement Tenancy Act.
Yes, my lord.
Then this under a municipal area, not a rural agricultural land, and status of land class also changed from agricultural residence class. From the report of circle officer in Gabura, it is clear that the respondent has not personally or through any subtenant has done any agreement on the national land, nor the respondent could establish voice number. The respondent did not produce copy of the Katiyan.
Yes, my lord.
Where is Katiyan?
Well, Khatiyan is a right created, my lord, towards the my lord, tenant to
Under the
cultivate,
act.
over the portion of land
Under the act.
under the act.
Since the land in question is no longer rural land, since its class already changed by the land diffusion from agriculture to residential class after taking into consideration the respondent. Under tenancy law is no longer allowed. You are respondent in this matter.
I am the petitioner in this matter.
Huh?
They filed an appeal before the Board of Revenue. There we were the respondent.
Huh.
The
In this
revenue appeal.
no, in this page 62, 60, you are the respondent.
I was the respondent.
This is against the Board of Revenue.
Yes, my lord.
Order passed by the learned additional deputy governor Jorhat. TSA means
Settlement, my lord, appeal.
huh?
My lord, title settlement application, I guess.
This is by the additional deputy commissioner.
Yes, my lord.
He is the officer,
Yes, my lord.
settlement officer.
Yes, my lord.
Then
Page 38 was the initial order by which the ownership right was granted in favor of,
you don't have to.
yes,
And then appeal was filed
by
before
the
the Board of Revenue.
Board of Revenue.
The Board of Revenue, based on the ground that it has been it's no longer agricultural land.
Yes, my lord.
It has been
Converted to residential.
residence and the and you have not agriculture and you have not been able to establish your position also.
Well, this is contrary to the report submitted by the ADC. Well, this particular finding is out of record and there is no evidence. And another ground that the class of the land has changed, well, there is a judgment of this honorable court by coordinate bench. Class of land change of land, well, do not ipso facto affect the right of the tenant. Well, the Khatiyandar or the tenant, there is a procedure prescribed under section 50 of the act to evict the tenant. Unless and until, my lord, that Khatiyan is cancelled, my lord, this transfer of right, my lord, cannot be, my lord, dealt in favor of the respondent who claim to be the owner of the land. Because there is a procedure prescribed under the act by which, my lord, a tenant can apply for ownership right as per section 23 of the act. And in pursuant to the provision of section 23, the ownership right was granted in our favor. And the Board of Revenue cancelled that ownership and the order on the ground that I could not establish my possession over the land, which is contrary to the report submitted on 12/8/2015, which your lordship will find at page 23.
Page 23.
Yes, my lord.
Problem is, where is this other side?
Name shown in the list of our call.
This is by whom? Circle officer again.
Circle officer, the report submitted to the additional deputy commissioner.
Are they referring to this? The
No,
Board of
my lord.
Revenue referring to this order?
My lord, there,
The report.
my lord, in the order, none of the order is reflected. Merely the observation is made that I failed to prove my possession over the land. But so far as the two reports are concerned, there is no reflection of the report, my lord, in the order passed by the Board of Revenue.
But if the applicant cannot show his position over the plot of land, huh?
Yes, this is contrary to the report submitted on 12/8/2015.
No, it says so.
My lord, with refer, if I may read the report submitted on 12/8/2015.
Yes.
With reference to the subject cited above, it is to inform you that as per the application filed by Sri Dhoniram Chutia, that is the petitioner, his father was possessing the suit land situated at Jorhat town of 3 number Moja block number so and so, measuring an area of 6 biga 4 kata 6 lechas.
You are Dhaniram.
Yes, my lord.
Huh?
Yes, my lord.
Yes.
As a Rayati Khatiyan number 59, the aforesaid Khatiyan was obtained from previous Pattadar Mohammad so and so, son of Noor, whose name was in the records when the Khatiyan was obtained, which has come to light as per the investigation of the Lat Mandal. During the course of the time, the aforesaid land was sold jointly to Sri Akon Kolita, Srimati Savitri Kolita, and Moni Kolita, and in the year 1974-75, as per the order dated 25/8/75 in the mutation case number 139, their names were mutated by virtue of their purchase. On the other hand, the class of the land of the aforesaid Dag has been converted to a residential class as per the order passed by Deputy Commissioner in so and so. Therefore, it is not known as to how the class of the land under possession of the Dhoniram Chuti as a Rayati Khatian holder has been changed. It is the report. And whether the Rayati Khatian holder
It
has
is not known as to how the class of land under possession
under possession.
has been changed with.
And whether the
whether the-
Rayati Khatiandar holder has denounced their possession over the land previously during the time of spot verification, the applicant could not show his possession over the plot of land.
Huh.
Thereafter,
Who is the applicant?
I am the applicant.
So,
The relevant paragraph is thereafter. Again on 29/6/2015, as per the order.
no, that's the first one. Previously, during the time of spot verification, the applicant could not show his position.
That spot verification was done not in my
Thereafter,
presence.
again, on as per the order so and so, what JEC? When the
But
spot
in
was
JEC
visited,
number, when the
land
spot was
measured-
visited for investigation, a land measuring 4 gata 5 lecha of the aforesaid Dag was found to be under the possession of Rayati Khatian holder along with the
Along with-
Pakka boundary wall. I am the Rayati Khatian holder.
No, it's not. It's found to be under the position of Rayati Khatian holder.
Yes, I am the Rayati
Ah.
Khatian holder.
On the other, as per influence of Patra, that the said land bounded with Bhagavad was under the position Manjula Datta.
Hmm?
We did not find any cultivation of crops or other action. The opposite report is submitted on the basis. Yes, this is also correct.
The
Did not
cultivation
find
over the
any
land,
cultivation of the crops or other illegal activities.
cultivation over the land, plot
If
of
it is
land,
converted to the residential purpose,
it doesn't affect the right of the Rayati Khatiandar, as per the judgment passed by the coordinate bench of this honorable court.
but the policy is this Rayati Khatian is given if it is agricultural land.
Thereafter, it creates a right. It is the law of the land, my lord. It
No,
creates a-
problem is what is the respondent, because this will affect his,
My lord, I
Isn't
have
it?
been instructed that Mr. J. Roy has returned the brief. Just now I inquired and he has given a NOC.
what is to be done in that case?
Can it fix some alternative procedure?
Because it will be difficult,
Yes,
once you say that this has been wrongly, if we interfere,
Yes.
it will affect him.
just now I have inquired.
So what is to be done? You take a press notice in that case.
Press notice, my lord, it may be fixed after 2 weeks, a date may be fixed. In the meantime, they may engage.
Inform them under that. I will respond.
My lord, they may engage a council. If on the next day they do not come up, my lord, then there is a procedure to issue notice to the private respondent. Because NOC has been issued in favor of the
We
respondent.
don't know, it's not on record.
Let us try on the next date, my lord. If they do not turn up, my lord, then
Or Mr.
as
To
discussed.
unnecessarily making it, and if you can run, if you can take not steps. So that unnecessarily after 1 week again, we'll have to again issue notice. I mean, we'll have to issue notice. Or we'll issue a notice. We'll issue a notice.
It will be better for him.
Heard Mr. So-and-so, learn counsel for the petitioner and Mr. Both of you, again. Yes, same. Don't appears for the, for respondent number 2 and 3 and 4.
Yes, my lord.
Mr. It is brought to the notice of this court. That
Only
the
3 and 4.
Earlier,
3 and 4.
3 and 4. The earlier engaged counsel, Mr. J. Roy. The senior counsel has been, has returned the brief to the respondent number 3 and 4. Mr. Perhaps due to communication and perhaps due to communication gap, the respondent 2, 3 and 4 are,
3 and 4.
the 3 and 4 are not represented today. Mr. Having considered that the issue relates to issue raised in writ petition pertains to ownership of the land claimed by claim by
The petitioner
petitioner
as
as
a
well as-
Khatyandar.
and counter claim by the respondent number 3 and 4,
Yes.
notice be issued to the respondent number.
Your
3.
lordship may, if I
three
may
and
suggest,
four.
my lord, a notice may go from the registry, my lord,
That's
because
what I'm saying.
my lord,
Notice be
I
issued
need
to the-
not take any
notice
step
be-
because we have already.
Notice be issued to the respondent number 3 and 4. Listen. Accordingly, registry to issue notice to the respondent number 3. Let this matter be listed after 2 weeks.
Much obliged.
Unnecessary because
Yes.
of the pending, otherwise they could have finished
Yes,
it up
yes.
today.